Good morning, folks. This is the Colorado Oil and Gas Conservation Commission. It is 10:30 on August 16th, 2021. And today is a continuation of our KPK enforcement matter. That is docket number 2011-00261. We will start with the roll call.
Thank you, Mr. Chair. Commissioner Bogue, Commissioner Gonzalez,
Here.
Commissioner Hackett, Commissioner McGowan,
Here.
Commissioner Mesner,
Here.
Commissioner Nanjapa,
Here.
Commissioner Robbins.
Here.
Mr. Chair, you have 5 out of 7 commissioners present.
Great. And those are the 5 that we were looking for. DNR and CDPHE have been excused and are not required to be in attendance for this matter. So good to see everybody. Hope you had a wonderful weekend. I had a wonderful weekend. I was out and about doing all kinds of stuff. I'm kidding. We were all working diligently on this matter. And so I want to thank the commissioners ahead of time for the effort that I know we all made over the weekend to be prepared this morning for deliberation. Want to sort of walk through what I think is a sensible approach to our day-to-day. We have several matters before us. We have the motion on the statute of limitations, and then we have 5 different enforcement matters. I suggest that we take up the statute of limitations motion first and deliberate on that, and then see if we've got consensus around what our position is relevant to the statute of limitations. We then can apply whatever our consensus is to the NOAVs that have statute of limitations implications when we take up those NOAVs. So that's my first thought, is that we would start with that. Secondly, I think we should obviously take these up one at a time. I will inform the parties that in order to sort of jumpstart the presentation and the deliberation of this, we did the math and there were 5 violations and there are 5 of us. And so we have assigned to each one of us sort of a deep dive into the NOAV. And then we all obviously also dove into every single other NOAV so that we're ready to talk about it. But this will allow one commissioner to sort of jumpstart the dialogue, the discussion, the deliberation on the assigned NOAV that was assigned to that commissioner. I suggest that we take them in the following order: the Nesu number 1, then the Nesu Consolidated, then the UPR PAM, whatever that one is, followed by Soils Spreadfield, and then finally Jolson. There is some meaning to that order. In particular, the 2 Nesu ones have statute of limitations implications, and so it seems to me that it makes sense to take those up first. As we take them up, the plan is to reach an interim decision that is not going to be a final decision. Obviously, we still have 3 other NOAVs to take up, and then we need to have a hearing on the pattern of violation. I suggest that we take them up and take into account some of the aggravating or mitigating conditions, such as the allegation of COVID or responsible party, but I do not suggest we take up today either the pattern of violation, because we've not gotten to it yet, nor do I think it's appropriate to take up ability to pay considerations today. I think that pattern of violation obviously needs to be taken up after we've made a decision on pattern of violations. Ability to pay, I think, is a issue, a mitigating circumstance that we do need to adjudicate, but I think that the proper time to adjudicate that is once we have all 8 of the interim orders in place, once we have the pattern of violation decision made either way, then at that point, sort of the last piece would be consideration of ability to pay. I'm going to have Hearings Manager Larson bring up on her screen at the appropriate time staff's claims table, just as a starting point. And then if we find penalty or violations, and then as we walk through the classification, the all the other elements that we're going to be walking through, the minor, moderate, et cetera, Ms. Larson can make corresponding changes if we were to make changes to that. That way, we've got something that we can look to for in terms of our discussion. If we, in consideration of an NOAV, find that there is general consensus amongst ourselves, in talking with AG Davenport over the weekend, I don't think we need to have a formal motion. We can just sort of say, okay, thumbs up, we all are in agreement. That's where that one needs to land. Obviously, there is the potential that we do not have agreement with regard to a violation or a penalty. And so if it gets to a point where it's not sort of uniform consensus, I'll probably call for a vote. And I remind commissioners, there is nothing to be sorry about, nothing to apologize if we end up with split votes. That's fine. I also note to commissioners and to our 51 attendees that this is our first rodeo doing this. Normally, judges, when they hear a case, they then go into their back room, they figure out what they're going to say, they type it up, and they send it out. Well, we don't get that luxury because we're an open public body. So bear with us as you watch the sausage being made. We have done, I think, a very outstanding job of listening over the course of the last week to all sides. And it says my internet connection is unstable, which is strange because I'm in the office. So hopefully I will not go away. With that, I guess finally would like to, and with no offense here, but remove Director Murphy and Mr. Peskin from the panel so that it's just the commissioners with our hearings manager and with our AG for purposes of deliberation. We're not taking any further, well, actually, let me ask this question. So the question for commissioners is, having gone through your assigned NOAV as well as the others, is there anyone with a need relevant to additional testimony? I'm fine, and I'm hoping folks are all good and we're ready to go. Okay, I'm not seeing that, so that's great. So with that, I just want the 5 of us on the screen, as well as Hearings Manager Larson and our Attorney General support with Kyle Davenport. And then I guess I'm going to look to everybody. Does anybody have concerns about the process that I just suggested? Everybody's sort of thumbs up in it? Okay, that sounds good. All right. With that, we have a motion for partial summary judgment based upon an argument that the Statute of Limitations, which is a 1-year statute under our statute, that it precludes consideration of several of the claims within Nesu number 1 and Nesu Consolidated. As I mentioned, I think it probably makes sense for us to have a dialogue amongst ourselves about the arguments tendered by KPK as well as the arguments tendered by staff relevant to how we should assess the statute of limitations and whether our statute contemplates either expressly or impliedly a continuing violation notion that would extend the statute of limitations. So I've got some thoughts about that, but I'm more than happy to let someone else run lead if someone wants to run lead or speak first. Commissioner Messner.
I don't have to speak first, Mr. Chair, if you want to share your thoughts, but I do have thoughts on this.
Go ahead. Maybe I can follow up.
So I've written some of this stuff down, so I am reading a little bit of my thoughts on this.
Me too.
But to determine my view on this item, I reviewed all of the parties' statements and arguments, the relevant cited case law, and the applicable COGCC rules, as well as the Act itself. The Act provides the following statute of limitations for commission enforcement actions, quoting, No action or other proceeding based upon a violation of this article or any rules, regulation, or order of the commission shall be commenced or maintained unless it has been commenced within 1 year from the date of the alleged violation. That's CRS 346115. That had been cited by both parties. Commission Rule 523C3 indicates a service of an NOV constitutes commencement of an enforcement action. The act authorizes daily penalties for, quote, each act of violation per day that such violation continues, which is CRS 346121-1A. I believe COGCC staff is claiming that there is clear indication of intent within the act regarding the continuing violations doctrine. Their argument utilizes the penalty clause within the act and longstanding COGCC practices, as well as looking at the act as a whole to come to this conclusion. I believe KPK argues that by labeling and treating enforcement offenses as continuing violations, staff has departed from evident intent of the General Assembly to provide statutory time limits on enforcement violations. And again, both parties cite a number of similar and different case law citations to help make their arguments on the issue in their pre-hearing statements, responses to motions, and oral argument. So based on the information provided and my own research, my interpretation is as follows. The Act clearly contemplates a statute of limitations for enforcement actions, though not for penalty calculations. CRS 346115 does not include language that courts have found to show a legislature's intent to make continuing violations available, such as the use of the word continuing or stating that each day of violation is a new violation. However, CRS 346121-1A does authorize daily penalties for each violation per day that such violation continues. I believe enforcement actions commence upon issuance of an NOAV. Statute of limitations begin when staff actually or through reasonable investigation could have discovered a violation. I will call this term the regulator's day of discovery. So in plain terms, and hopefully this is clear, the regulator has 1 year from the regulator's day of discovery of a violation to issue an NOAV, and the continuing violations doctrine is not available to extend the limitations beyond limitations period beyond 1 year from the date of discovery. I do believe, however, that the Act clearly authorizes daily penalties for each act of violation per day that such violation continues. So I do not believe the statute of limitation applies to penalty calculations associated with violations made within the statute of limitations, but where impacts occurred for longer than a year, as can be shown by necessary evidence. So those are my thoughts currently.
Thank you, Commissioner Messner. I tend to agree. I wrote down some thoughts as well.
Sorry, Mr. Chair.
Yeah.
I was wondering if Commissioner Messner could give an example of how he's splitting the hairs with calculating the penalty that might be longer than the statute of limitations, just so I make sure that I understand.
Yeah, I'm not sure I follow that point.
I just want to make sure that I'm understanding his point.
Sure. So, and this is a hypothetical. So if staff through a complaint finds out about a situation that occurred a year and a half prior, so let's say that they found out about that on January 1, and that could have been the only reasonable time that staff could have known about it, but there was a clear continuing, there was impacts that existed for a year and a half, assuming that the NOAV for that act was issued within 1 year of January 1, 2021, then the actual penalty calculation could go back further than a year if there was clear evidence of impacts associated with that with whatever that violation was. So that's how I would interpret that. And also to give another hypothetical, if you've got an NOAV with a number of unique and distinct violations associated with it, and some of those violations are outside of the statute of limitations, and some of those violations are within the statute of limitations, and they are unique and distinct violations, then the ones within the statute of limitations in that NOAV would still apply.
Commissioner Gonzalez.
Sure, and thank you, Mr. Chair. I am almost in complete lockstep with Commissioner Messner's analysis of the statute of limitations, and I've kind of summarized it in my notes based on what I believe is kind of as follows, right? I believe that there should be a continuing violation, and I believe that the violation should be continued and the statute of limitations told based on the discovery date of the enforcement action, and that discovery date should be the date when staff knew or should have known through exercise of reasonable care that the violation existed. I think that to think that a violation could go on for over a year or longer without any knowledge or any, I guess, knowledge, actual or constructive by staff during that time, and that an operator could escape penalty for that violation, I think that's an absurd result. I don't think that that's what the legislature intended. So as to kind of how we're putting sideboards on statute of limitations, I do think it continues up to, or at least is told up to, the date of discovery by the enforcement agency, being COGCC in this regard. And I've kind of taken that analysis as I've reviewed the two statute of limitation defense violations that we've had before us over the last week or so. So I kind of want to jump in and support Commissioner Messner's argument for how we should interpret statute of limitations. And I think he and I are on the same road, on the same path in our analysis.
Thank you, Commissioner Gonzalez. Go ahead, Commissioner Nanjapa.
Thank you, Mr. Chair. I just wanted to also jump in. I made the same interpretations based on the language of the Act, that the statute of limitations pertains more specifically to the issuance date of the notice of alleged violations and the date, and as that relates to the date of discovery by staff. And that was something that we heard in testimony from KPK as well with respect to date of discovery by staff. Oh, and sorry, I wanted to also add that I also believe that it does not apply with respect to the penalty calculation, and that's a separate matter as it relates to the statute in 346121, and that the penalty calculation may be longer. I agree with what Commissioner Gonzalez just said, that I also believe that while a year from the date of discovery by the regulator is appropriate for the issuance of the NOAV, the evidence that supports that the violation had been continuing prior to that does allow for a different penalty calculation, a different set of different time frame for penalty calculation. So that was my interpretation.
Thank you, Commissioner Nanjapa. I tend to agree with what my fellow commissioners have said. I'd like to add in some context to where I got to. I looked at the cases and recognized that in both state and federal case law, violations can be continuing for statute of limitation purposes only where there is explicit statutory language to that effect, or the violation is one the legislature assuredly intended to treat as a continuing one. That's the two-seat case. And I read our statute. It's one sentence. It doesn't use the word continuing violation. So I don't find there's express authority for continuing violations. nor do I find implied recognition of continuing violations in the statute. I know that staff look to the daily penalty calculation but as implied evidence, but I think the better argument is on its face that section indeed addresses the penalties aspect of enforcement, not the statute of limitations aspect on enforcement. I would also like to argue that SB 19181's mission change, moving away from fostering to regulating in a manner that is protective of public health, welfare, safety, the environment, and wildlife resources, that legislative change brought continuing violations into play. I'd like to say that because that allows the commission to this new statute allows the commission to not only regulate, but to enforce in a more protective manner. But I note that SB 19181 did not make any changes to the one sentence in section 346115, which is the one-year statute of limitation that has been unchanged since 1963. I also read some of the cases, and in particular the Chemix case that was cited for the proposition that the statutory scheme, which contemplates daily penalties, indicates legislative intent for violations to be continuing. But I read that case over the weekend and I reread it this morning, and I just can't find that case stands for that proposition. And so I don't find that is supportive either. And then finally, I searched some of the other statute of limitations for Colorado administrative agencies. I thought maybe looking to see what the legislature did for other agencies would be helpful, and I find that it is. The Division of Reclamation Mine Land Safety statute of limitations says each day of continuing violation may be deemed a separate violation for purposes of penalty assessments. So that statute specifically says continuing violation. And then the Public Utilities Commission statute actually is even clearer. Each day of a continuing violation constitutes a separate violation. So in my reading, the legislature knows how to put in continuing violations. They did it with some sister agencies. They didn't do it with us. They didn't make that change in SB 19181. And so I would agree with my fellow commissioners that continuing violations does not come into play in the enforcement context at this time. Go ahead. Yeah, AAG Davenport would like to summarize where we are, but I do see that Commissioner McGowan has raised her hand, so perhaps let's let Commissioner McGowan go first, and then AAG Davenport, if you could summarize where we are, I think that would be great.
Thank you, Mr. Chair. So just making sure that I'm understanding where you're going, Mr. Chair. No continuing violations, but the door is open for a violation to happen separately each day as a new violation?
No, that's the same thing. What I'm saying is that the continuing violations doctrine, which extends the statute of limitations, does not, in my opinion, apply to us.
Whether with plain language or implied, you don't think it applies
I don't find
either instance for us.
Either instance for us, right? As I went back and looked at our statute and I looked at the case law around that, I'm in agreement with my fellow commissioners about the date that a violation starts to accrue, and I'm in agreement with the ability of each day of penalty, even if it's beyond. But I'm not finding that continuing violation continues to accrue or not toll the statute.
So for someone who's not a lawyer, could I ask for some advice about, I think staff has historically been using the tolling of a violation, the continuance of a violation, and to date, I think it's been accepted by those who have been regulated. So is there some significance to how the department has historically been using continuing violations as support for implied usage?
AAG Davenport, can I turn to you? I mean, I've got a thought about that, but perhaps it's better coming from you as our attorney.
Thank you for the question. So staff has historically interpreted the act to contain a continuing violation doctrine. I don't believe that the commission has reached this issue. To my knowledge, the commission has not reached this issue, and that's primarily because contested enforcement actions were so few and far between. I think most were resolved through AOCs, which are settlement agreements. So in other words, there is a historical practice in the sense that staff treated the continuing violations doctrine as viable under the act. But I don't believe the commission has really ever decided that specifically. It has certainly approved AOCs that were based on that, but it has never actually reached that issue specifically. This agency's interpretation of its act is entitled to deference, and perhaps if there had been historical interpretations of the act, a longstanding interpretation, that a court would defer to that as well. There is some question in my mind as to whether or not the staff's historical view of whether or not continuing violations was available is entitled to that deference when the commission has never actually reached the issue and decided it in a contested case.
Commissioner McGowan?
Thank you, Mr. Chair. So sorry, again, not being a lawyer. It seems to me that we have set some precedents already as a commission approving NOVs that haven't been contested, but that we have approved where staff has applied continuing violations, and the operator has accepted that as part of their settlement with the COGCC. And so I'm just wondering if that can be considered as part of our deliberation. It's interesting to me that this is the first time the commission has heard from an operator that continuing violations cannot exist, yet they've been applied historically and repeatedly for violations and settlement agreements with those same operators.
Yeah, and I think at least
Do you
in
see
my,
what I'm trying to say? I hope I'm making myself clear. I'm not sure that I am, but
yeah,
I'm just wondering if we can use that as part of the evidence that we're looking at in deciding whether or not continuing violations are implied.
so I look at this in this prism. Historically, and we've been a commission now for a year, right? Year and a month. And we have indeed approved AOCs that have come before us where the operator has agreed to an AOC where the continuing violation doctrine was applied, right? And my approval of those has been because the operator has agreed to that AOC. We have now been asked by an operator to make a determination on the continuing violation principle because they did not agree with the use of continuing violation. That is a question of first impression to this commission, in my opinion. And we were required to make a decision on that. I don't like the fact that at least my vote on the issue is that the statute does not contemplate continuing violations. I don't like the fact that the statute is a one-year statute of limitations. I find that to be not appropriate. And I think if we were to look at this realm of other administrative agencies, you're likely to not find a one-year statute of limitations, and you're really not likely to find a one-year statute of limitations where there's no continuing violation, which makes it tight. So I believe that our agency we are where we are if we look at our statute and we look at the case law. I don't believe that's the correct place to be, but I think that's the right decision that we've been required to, or that we are being asked to make of this operator. I find that different than the other instances where an operator has volitionally accepted continuing violation and has provided us an AOC for us to consider. AG Minor, not Minor, Davenport, did you have anything further about sort of case of first impression?
Yes, I think I'd like to chime in on something else as well. The deference that's afforded to this agency in its interpretation is only available where the act is ambiguous. In other words, where there's two reasonable interpretations. So I want you to understand that first. Also, my view of the deference entitled to a long-standing interpretation, I think that's when I said I had some question, I think is most directly applicable where the commission has decided in a contested case an issue, as opposed to it's been staff's practice in settling cases or asserting violations.
So
And I
just the
think-
commission passively approving those past violations would not be considered a commission decision in your mind?
That's somewhat accurate in the sense that the commission is not being called upon to decide a contested matter that the parties, staff and the operator, may have had a disagreement on, but did not bring that disagreement to the commission because they ultimately agreed to voluntarily settle the case through an AOC. I do not consider the commission approving an AOC to be a implied acceptance or decision on any of the underlying legal concepts that may have been presented by the case. And that would cut both ways. I think sometimes some people may view that as a good thing, and sometimes some people may view that as a bad thing.
Commissioner Messner? Commissioner Messner?
Thank you, Mr. Chair. And I appreciate your questions, Commissioner McGowan. I also really struggled with this determination because I would agree with Chairman Robbins that a one-year statute of limitations without explicit continuing violations doctrine is not appropriate for this agency. But that's not for me to determine, right? It's for me to interpret the statute that's available to us. I do think in application, there's oftentimes when COGCC staff tries to work hard with operators in order to be able to resolve problems out there and, extends timelines and, tries to really be a partner in trying to resolve some of these issues or violations that occur. And sometimes that does result in NOAVs perhaps being issued outside of that statute of limitations in the past. I would expect moving forward that operators are going to get less ability to work with COGCC staff, and COGCC staff is going to be more interested in providing more immediate NOAVs and to ensure they're within that statute of limitations. And so I do think that there's that potential impact from a decision like this as well. And so I think that can be expected into the future.
Other thoughts from commissioners? AG Davenport, you had suggested that you might try to summarize where you think you hear the commissioners are. That might be helpful.
Thank you, Chair. Commissioners, with your indulgence, given that at some point we will have a written order, and at least in the past, it's been my role to memorialize your deliberations in a written order. I would like to try to synthesize at this point. And I think it may be helpful as well, since we still have 5 more NOAVs, some of which that have statute of limitations defenses asserted to them, to kind of make sure that we're all in agreement on the principles that you've been discussing this morning. I think the first one is that you have stated that the statute of limitations, that 1-year period within which the staff must issue an NOAV, does not begin until this agency knew or by reason of reasonable discovery, not the best way to state that, should have known of the alleged violation. So the actual date of violation after investigation does not begin the statute of limitations unless staff knew of it at the time. And the statute of limitations does not begin generally until staff knew or should have known of that violation. So I think that's the first principle that you've discussed and generally all agree with based on my read. I think the second one is the continuing violations doctrine is not available to extend a violation beyond that 1 year where staff discovered it, knew or should have known of that violation. In other words, staff learned of a alleged violation on January 1, 2021, and does not issue the NOAV by January 1, 2022. The continuing violations doctrine is not available to allow staff to prosecute based on an NOAV issued more than a year after discovery. The third principle that I think you've discussed is as long as the NOAV is brought timely, the Act does authorize a penalty for every day within which the violation is occurring. And the statute, the Act, and our rules do provide guidance as to what should be the first day of violation and what should be the last day of violation for purposes of penalty calculation. And we'll discuss that more as well, I think, as you get into the specifics of the NOAVs. That's my summary of what I think you've been discussing. And if that is not what you've been discussing or needs correction, now would be a great time to make sure we're all clear.
Does anyone take issue with the three principled summary from AG Davenport? All right, seeing none. Again, our decisions will ultimately find their way into a formal written order that AG Davenport will work on and that we will review and assist. But I think we are now done with the general discussion, deliberation on the motion for partial summary judgment. I heard affirmatively from four of us that we're comfortable with this. Commissioner McGowan, I don't know that I actually heard from you if you're comfortable with this. You don't need to be comfortable. You don't need to vote in the favor. It's still 4-1 or 5-0, or I don't care. I'm just giving you one opportunity to further speak your piece on this.
Yeah, I begrudgingly agree. I'm disappointed that kind of the historic use of continuing violation can't be considered as implied usage for us to support the use of it, but I understand. Hopefully it'll get fixed.
Thank you for that. That's where I started and that's where I end, is that I'm not in favor of the decision that the statute and the case law is requiring us to make, but I think it is the correct decision based upon the statute that is our governing statute at this point in time. And I too believe that there could be and should be a review and a better approach articulated so that we have a statute of limitations that is more workable for this agency as we move forward in regulating in a manner that's protective. Commissioner Messner, you raised your hand as well.
Thank you, Mr. Chair. Just a quick question. While I'm 99% sure that the summary that AG Davenport gave us is where I'm at, can I reserve my opinion until we apply it to a couple of cases here and just make sure that I'm clear with what I think we're saying?
I think that's a wise statement, Commissioner Messner. And let's take what we think we have developed in terms of a principle and let's apply it in fact, and let's see if we've dealt with all the edges of this issue. And I'd say 75%. AG Davenport has shown back up, so let's see what he has to say.
Thank you, Mr. Chair. I appreciate the opportunity to say something. I think, though, we stated sort of three general principles. I do think that everyone listening, as well as yourselves, should understand that those principles would be applied in specific facts and circumstances of each violation. And there may be circumstances that we're not considering, special or unanticipated circumstances may come up in the future. And so you all should be aware that this will still require, I think, an analysis of each violation and the facts underlying each violation as well. Even though we've discussed some general principles today, there are, who knows what could happen in the future. And so I would like you and the general public to know that there may be something in a different case that changes the conclusion.
Okay, with that reservation, which I think is prudent and wise, thank you, Commissioner Messner. If Commissioner Gonzalez is up for it, we would turn to his introduction to us of Nesu #1 with his thoughts, comments, etc. And then we can all dialogue, debate, deliberate that NOAV.
Thank you, Mr. Chair. So as this is kind of the first rodeo for all of us, and this is in fact the first ride in the first rodeo with regard to an analysis of the various NOAVs that we have in front of us. I'm going to fumble my way through the two rules associated with the NOAV, or the two alleged rule violations associated with the NOAV associated with the Nesu #1 location and flow line. So to start off, we're talking about NOAV number 402550681, issued December 10th, 2020. The first alleged violation was a violation of Rule 901C for failure to submit the initial and subsequent Form 27s. There's a direct requirement to submit those Form 27s for an initial and subsequent work plan associated with remediation for the spill or release. And in evaluating the allegations in that NOAV as this rule, I've determined that I believe there are two separate violations of Rule 901C in this NOAV. And I'm going to walk through each of those. I'll kind of outline what they both are, and then I'll walk through each of them individually and kind of where I landed for discussion. So the first violation is in regard to the filing of the initial Form 19. And the evidence that I recall and that my notes support is that pursuant to KPK's October 18th filing of an initial, so the violation is not the filing of the initial Form 19, the violation is the corrective actions and the deadline associated with the filing in the Form 19. So let me walk back to the facts there. So pursuant to KPK's October 18th, 2019 filing of an initial Form 19 reporting the release at the Nesu #1 location, the director issued a Form 19 condition of approval and field inspection corrective action, including a deadline of November 30th, 2019 for KPK to submit the Form 19 site investigation and remediation work plan. I'm sorry, the Form 27 site investigation and remediation work plan. It is uncontested that KPK failed to meet this deadline. That Form 27 initial was submitted on January 23rd, 2020. 53 days passed between the deadline and between the submittal, excluding those days of 11/30/2019 and of 1/23/2020 when it was submitted. So that's the first violation. The second violation is once the Form 27 initial was submitted to KPK by KPK on January 23rd, 2020, staff set a deadline for the submittal of the Form 27 subsequent with a firm schedule for the removal of impacted soils. That deadline was set for February 3rd, 2020. KPK failed to submit that Form 27 subsequent on that deadline. That Form 27 subsequent was submitted on April 15th, 2020, and 39 days passed between the deadline for that Form 27 subsequent and the submittal of that Form 27 subsequent. So in reviewing and applying our statute of limitations analyses to both these violations, I'll take violation 1 first. In violation 1, I do find that the NOAB violated the statute of limitations in that regard. And what I find impactful there is the timing of the condition of approval and the deadline issued by staff of the November 30th, 2019 for the Form 27 site investigation and remediation work plan. When that deadline passed, staff knew it. Staff had actual notice of that deadline being passed with no submittal. That was over a year before the December 10th, 2020 NOAB was issued. And because of that, I find that violation 1 as to the corrective actions associated with the Form 19 and the submittal of the Form 27 violates the statute of limitations and should be dismissed and no penalty assessed. I'm happy to entertain discussions on that, or we can talk about that, or I can move on to violation number 2, and then we can kind of close out this rule, have discussions, move on to the next rule. So if everyone sees some nodding heads, I'll keep on going then. So with regard to the second violation, I believe in this regard that the violation was KPK's failure to meet that February 3rd, 2020 deadline for the Form 27 subsequent. It's uncontested they failed to meet that deadline. That was submitted on April 15th, 2020, 39 days passed between the deadline and submittal. This is well within the 1-year statute of limitations, and statute of limitations, in my mind, was not violated for this violation. I do believe that this violation did occur. I do believe that KPK was in violation of the rule for the failure to submit that Form 27. And there's some mitigating factors that I want to kind of walk through here that I've considered in kind of where I've landed on this second violation. So one thing I want to acknowledge that KPK self-reported the spill and endeavored to remediate a larger historical spill for which they may not have been the responsible party. I think that KPK did the right thing by attempting to address the historical spill under the Nesu 1 location. They just didn't do all the associated steps in the right way, and there's importance to those steps. The importance of the Form 27 is that staff has the appropriate level of engagement and oversight and participation to make sure that a site is remediated appropriately and is done up to spec and is done with the appropriate protections for the environment, for wildlife, for all the impacts that are associated with that spill release. And I think that it is important that staff has the ability to participate in that process, and that's why that Form 27 is so important. And not filing the Form 27 was completely within KPK's actions, right? That was within their responsibility. So even though they were endeavoring to do the right thing and to take on a bigger problem that may or may not have been theirs historically, they didn't follow all the steps the right way. Therefore, when I'm considering, I'll kind of skip ahead. So when I'm thinking about this, about the violation number 2, I'm thinking about the appropriate classification of the rule. I'm not inclined to change staff's classification of class 2 for this rule violation of 901C for the failures to submit the Form 27 subsequent. Again, I cite the importance of that form, and I cite the importance of that associated oversight by staff. In regards to the impact, staff has assessed a moderate impact for this rule violation. I did not hear any testimony that would lead me to believe that there was any actual adverse impacts of KPK's failure to timely file that Form 27 subsequent. I also believe that the work that KPK was doing to remediate the historical spill, the fact that KPK self-reported the release, should be considered to potentially net out any perceived impacts associated with this violation. So it's my suggestion that that we reduce the impact to a minor level for this rule. I do believe the duration matrix should be applied as staff endeavored to apply with their schedule of violation penalties. And so kind of to summarize where I've gotten to with kind of all this under Rule 901C is that I suggest that the KPK was in violation of Rule 901C, that they were in violation for 39 days, not the 115 days as set out by staff, and those 39 days were between the missed deadline of February 4th, 2020, or February 4th was when the clock started ticking, up to the submittal of their deadline of April 15th, 2020. And so those 39 days for a Class 2 rule violation with a minor impact. Applying that analysis, right, kind of where I landed there, and applying the duration matrix, I suggest the penalty would be for those 39 days, $37,250. In considering the mitigating factors, this is a big historic spill that KPK discovered, and it seemed that every time they dug into that wall, they discovered a further extent of that historic spill. And it went on, and it became quite an excavation site and quite a remediation activity. And I'm happy that KPK endeavored to take care of that. And I think that's important to consider specifically as to this specific rule violation. Given that, I think that there is an appropriate mitigating factors discount to apply here. I'm suggesting 20% for this penalty, which would bring the overall penalty to $29,800 for the violation of Rule 901C. So that's kind of my summary on my analysis for that first part of the first alleged rule violation under that NOAV for Nesu number 1. And I think it's probably appropriate to hear from the rest of the commissioners on where we're at with this and how it aligns with what they were thinking.
Okay. Commissioner Gonzalez, a couple of questions, and I kind of want to set up a process here. You went through a lot of information. You spent a lot of time with this. I'm trying to capture it on my notepad, but it might be helpful if we brought up, and Ms. Larson, are you trying to capture this on the claims table? Okay. AG Davenport, you're doing this on the claims table? What I'm thinking is there's a lot of numbers there, and it might be helpful to see it on a screen. So give us just a second while we do that. And then I had a specific question for you, Commissioner Gonzalez. Does the penalties that you've arrived at, are you using the duration matrix?
Yes. So the duration matrix, as I've applied this penalty, is using the duration matrix for a Class 2 minor violation as cited on the duration matrix in the enforcement penalty, page 22, I believe.
Okay. And then I had a follow-up. So your last adjustment was a 20% discount. Can you walk me through that again? I'm sorry. I missed
Sure.
it.
So one of the things that's been made available for our consideration is to consider the mitigating factors, and specifically in this regard to the responsible party determination as a mitigating factor. And I don't know that we endeavored as far to cite a responsible party or to identify KPK as not the responsible party, but I think there was plenty of testimony and evidence to suggest that KPK was endeavoring to mitigate a site beyond just their spill and to a historic spill that was likely occurring long before they took over operations of this flow line. So given that, I was trying to reconcile, hey, what's an appropriate discount? What's an appropriate way to apply this mitigating factor? And without the benefit of having historical practice in this regard, I thought that a 20% discount seemed appropriate, and that's why I've suggested it.
Okay. And I'm sorry, but another question. When I heard you speaking to moving from moderate to minor, one of the reasons that I think I heard was self-reporting and this work on historic spill. So is the moderate to minor also sort of a contemplated responsible party thing, that they did the right thing on top of the 20%, or are those separate in your mind?
They're separate in my mind. I think there's a minor impact here, given that KPK self-reported. They filed the Form 19 initial at an appropriate time frame. It was the subsequent time frames with the Form 27, with the remediation work plan, that when I consider that against the impacts threatened or actual, I think that it's appropriate to consider it as a minor impact. And I did consider the historic spill as a potentially mitigating factor for that determination of that impact level, because I wanted to think of the net impacts of the failure to file the form timely, and the net impact, or the offsetting impact, if you will. I don't know if it's quite offsetting. I'm probably not using the right terminology here. But the net adverse impacts that would have come out of not having remediated the spill and having endeavored to work through it. Now, I don't know that if KPK was just dealing with their own little spill, or their own spill they had with the Nesu #1 flow line that was discovered, if that would have kept them on time with submitting their subsequent forms or not. I don't know. But I think that just given the extent of it, that it's appropriate to consider not only a reduction of the impact, looking at it from a net impact perspective, but also a reduction as kind of a haircut over the final penalty, just given the efforts and the expense that they went to remediate a spill that that likely wasn't theirs. So that's just my thought process on it, right? If I'm landing somewhere as one commissioner, that's that's my suggestion.
No, I appreciate that analysis. And for other commissioners, I now have a question. So we've heard from our first commissioner that was assigned a case. Are you ready to sort of have questions with ourselves about this? Do you want to look at your notes a little further to sort of think about your notes versus where Commissioner Gonzalez is? And I just don't want to miss out here. So what are folks' ideas? Commissioner Messner?
Thank you, Mr. Chair. I've got some clarifying questions to make sure that I understand Commissioner Gonzalez's proposal. And so I guess I would propose that we ask some clarifying questions to make sure that we understand. Once we understand, then I think perhaps
Taking 5.
we could have an opportunity then to share whether we agree or not, or whether we have a counter proposal.
Okay, so that's a good idea. So again, we're creating this as we go. So let's have each commissioner provide their initial perspective. Let's start with clarifying questions, which is kind of what I was doing as well. And then after that, we would move into sort of deliberation. What are other commissioners' thoughts, not only about the proposal, but about where they were with regard to finding of the violation and then penalties. So, and I told AAG Davenport to try to make the changes and track changes so that we can see where staff started and where we potentially are at this point. So with that, Commissioner Messner, please ask clarifying questions.
Thank you, Mr. Chair. So I'm just trying to make sure I understand the days of violation that you've calculated there, Commissioner Gonzalez, because my understanding is, as is being tracked on this, that you're suggesting that the violation occurred between February 4th and April 15th. I don't think that's 39 days. I think that's 70 days. And so I think I heard you say 39 days, unless I'm wrong. And so I'm just trying to understand that.
I did say 39 days, and that's what I had in my notes, but perhaps my math was wrong in tallying that up. So I'm looking at those dates from February 4th to April 15th. So 15 days in April, or 14 days in April, 30 days in March, that is 44. So off there. And then, yeah, so I must have missed some math in there, but I'm hoping that none of my math, or that all of my math, should I say, is checked in this process, because there's a lot of math involved, right? I had my scientific calculator out trying to work through the duration matrix. And so please check my math. I think the intent of what I'm trying to get at is that the dates should be February 4th to April 15th, excluding the April 15th date because they cured on April 15th. So perhaps the end date should be April 14th. And that is part of my proposal. And sure, so whatever that math ends up being, I apologize for my my fat fingers, or for maybe even skipping a week as I was calculating out and counting down out of my calendar. So thank you for catching that. I did mean the appropriate dates. I did say 39 days, and I do believe I was incorrect with that addition.
Okay, so I'm setting the record straight. None of us can apologize for anything we're doing. This has been a very long weekend. It was a long week. We're all doing the best we can. So no worries there, Commissioner Gonzalez. Just a second, Commissioner Messner, I'm going to get it right back to you. AAG Davenport, do you mentioned to me you had a suggestion. Do you want to suggest?
Yes, thank you, Mr. Chair. Commissioners, I am happy to be the one that actually calculates the days of violation. If you all reach agreement on the actual start and end date, so that we don't, and I'll do my best. I've got an internet function open or some type of calculator open right now to just punch in 2 dates and get the days of violation. And please rest assured, we will go back and make sure when we prepare the final order that the math is all correct as well.
Okay, I think that's great. I'm glad you found a calculator that computes days. Commissioner Messner, you're up.
Thanks, and thank you, Mr. Chair. Just another clarifying question. So did you do that duration matrix and therefore the associated penalty that you stated on 39 days then? So no big deal. I'm just going to erase it all if that's the case.
The final numbers based on not having the correct days are now all incorrect. So whatever math that equates to is the math that I was intending to land at.
Okay, staff and AAG Davenport are going to be able to run the numbers here, including the revised duration matrix. So we can just focus on violations starting and end date, and then they can calculate it out for us, if that's okay with folks. Okay, Commissioner Messner, I believe you still had the floor. Commissioner McGowan.
Thank you, Mr. Chair. Commissioner Gonzalez, I think what I've been struggling with for this one, with the 20% reduction, is that it's kind of a paperwork violation. And so I get that they are cleaning up historic that they didn't know existed. I'm not sure about the reduction because it's how we're tying a paperwork reduction and not turning in a form timely with historic cleanup that wasn't theirs. And so I'm not sure I'm supportive of the 20% reductions. If you could flesh out a little bit more what your thoughts were in making that connection, it might help me.
Sure. So my thought is, when we think about what happened with this Nesu, or when I think about what happened with this Nesu #1 site, I don't want to disincentivize an operator from going in and cleaning up a bigger spill that they may discover. And I think that we're going to have a lot of operators who are out there who are doing the right thing anyway. And it's in the practice of, hey, this excavation went on for a lot longer. It involved a lot more in terms of coming up with that work plan and that remediation. And I don't know that we heard testimony from KPK saying that was the reason why they were delayed. And in fact, again, when it came down to all these violations, all the violations alleged here in this one and all the other ones I reviewed, it seemed, to me like the violation was wholly within KPK's responsibility, right? And that KPK failed to meet the rule requirements in those regards. So when I thought about the mitigating factors, I just thought that I want to find a way to say, hey, look, KPK spent a lot of money to get this site cleaned up. They could have done it a different way. They could have, just let the commission know about it, said, hey, I'm not the responsible party, and found ways to have that work covered or to be reimbursed for some of those expenses. They didn't. And part of the remediation that they were endeavoring to do required these forms, and I'm just trying to give some credit for the expense and the effort that went into a much larger project than I think was originally anticipated or would have been associated with KPK's spill and KPK's flow line at the Nesu #1. And so that's really all I was thinking about. I don't know if I landed at the right number for what the mitigation factor should be, if any. But I do want to recognize that. I think, this is a paperwork violation. And when you think about the calculation of 72 days at either whether it's $2,500 or $5,000 a day for a paperwork violation, I think looking at that in, with consideration of kind of the bigger picture, what was going on at the Nesu number one, I came to the conclusion personally, individually, that a 20% reduction seemed fair to me. And that's about it.
Commissioner McGowan, follow up.
I guess my thought for this too is that I did not hear testimony from either party that there was any communication to say, this is feeling overwhelming. I'm not going to get that form in on time. Can I have an extension? This is a much bigger spill than we anticipated. It wasn't even ours, and it's creating more work. And now I'm not sure what the right solution should be. Can I have a little extended time? And so if I felt there was like some sort of good faith effort, I think maybe so that's just my thought on that. But thanks. Thank you.
Other commissioners? Commissioner Nanjapa?
Thank you, Mr. Chair, and thank you, Commissioner Gonzalez. I appreciate the reasoning behind this. I think I tend to agree with Commissioner McGowan on, the reasoning behind the reduction with respect to the form. I do believe, and I do agree that there is something to be said about the additional effort that was made with respect to the cleanup. And I think there's something there. So I guess I think I need, as you all know, it takes me a little time to wrap my brain around things. So I would like a little time to kind of chew on this, but I think I do very much appreciate what you laid forth and the explanations. And again, I do believe that KPK does get some credit for going beyond with their cleanup. How that actually ends up looking, I think I might need a little more time to think about. But I guess I tend to agree with Commissioner McGowan that with respect to the submission of the form and with respect to lack of communication with the, once they knew it was going to be delayed, that I think that is important to maintain the days of violation and the amount of the violation, because they had every opportunity to give COGCC a call and explain what was going on and why they were experiencing delays.
Commissioner Messner?
Thank you, Mr. Chair. Just a couple of thoughts on this one. So I do acknowledge the efforts to clean up a historic spill, and I do think that there is certainly a cost associated with that, and appreciate that KPK dealt with that particular situation. And so I do think that that's a mitigating factor. I'm a little uncomfortable with calling this a forms violation because it's really not a forms violation in my mind. I think that the information that's provided on those forms directly mitigate threats of significant impacts to public health, safety, welfare, the environment, and wildlife resources. I think it's a plan of action and a direction to an operator to ensure that even if they're cleaning up a historic spill, that they're doing it in a manner that is protective. And so I think that this is not a forms violation. I do think that my looking at the impact classification, I have a hard time dropping it to a minor. I do think it's a moderate impact. However, I do agree with you, Commissioner Gonzalez, that due to the fact that this operator has taken expense to address a historic spill, that a 20% reduction in the overall penalty amount should be contemplated. So I'm splitting the baby there.
Commissioner Messner, sort of my thoughts on this, and to my fellow commissioners, I tend to agree with those of us that are having trouble with this just being a forms violation. I think this is the first case of multiple cases in which we are going to be looking at a course of action by this operator that is not consistent with the appropriate course of action for operators in our state. Our enforcement is a forms-based enforcement, and we heard all of our enforcement specialists talk about it's to generate dialogue between the operator and our enforcement officers. And that dialogue through the forms is necessary to ensure protection of health, safety, welfare, the environment, wildlife resources, minimizing adverse impacts, making sure that there are no threats, making sure that there are none. And so without the forms, without the reach out, that dialogue doesn't take place, which has, I think, significant implications to enforcement being able to do its job. If we had an enforcement team of 5,000 people, that might be different because we'd have more eyes on the ground, but we don't. We have an enforcement team of a couple dozen, I don't know exactly how many. And so that dialogue is absolutely critical and necessary through the filing of forms. And as I've gone through the NOAVs over the weekend and listened to the evidence and testimony, KPK seemed to have a conscious decision that the dialogue wasn't going to happen, that they were going to make gut calls on their own as to whether they needed to file a form or not. And I'm not encouraged to reward that. I think that's one of the critical underpinnings of this entire set of cases. And so I think I land where you are, Commissioner Messner, that it's not a minor, but it's a moderate, but that I do agree with the percentage reduction because they did the right thing in terms of undertaking this cleanup for a historic spill. So that's kind of where I land. And now we've all had our chance to sort of initially dialogue. I also wanted to give ourselves a chance that if we wanted to go look at all of our notes and things to take a short break, Commissioner Najapa, I'm trying to, we all roll in different methods, but if that would be helpful, I'm perfectly fine to call a 5 or 10 minute break to give everybody a chance before we try to finalize our initial deliberations on this, or we can go forward. I just want to accommodate each of our work styles. Go ahead, Commissioner Najapa, and then Commissioner Messner.
Thank you, Mr. Chair. No, I certainly would appreciate at least 15 minutes. I think that would be helpful to go back through a few notes. And I think in my mind, as I noted, I do agree that there should be some concession made given the efforts that they made. I was thinking of it more in relation to the 907A violation, but I can kind of understand, the reasoning that you and Commissioner Messner are coming to. But yeah, I want to think about that a little bit. And I did note that there was, specific testimony about that Form 27 being a dialogue. And I believe it was one of the KPK witnesses who said that, there was no dialogue to be had, so we just continued with our excavation, but they didn't provide the form to even initiate that dialogue. And so I think that in itself, I agree with what you noted, Chair Robbins, about there seemed to be an understanding of what needed to happen, but perhaps a decision that it didn't need to happen in the time frame that had been requested. And so I think there's something to that we need to consider. So yeah, I guess I'll just leave it at that. And, if we can take at least 15 minutes, that would be great.
Let me throw out another suggestion, and Commissioner Gonzalez, this is going to be directed directly at you, and it may be what you're thinking about as well. We do have your other claim. Perhaps we could hold this one, let you present on the other claim, and then break for lunch, and then come back and finalize deliberations on both claims, given the point that Commissioner Nanjapa just made about sort of where's the percent haircut for them doing the right thing? So commissioners, I look to all of you, but in particular Gonzalez, because now I'm putting you on the spot.
I fully support that.
Everybody okay with that? Okay, so we'll put this one down. We'll take some notes. We'll listen to you, and then we'll take our 45-minute lunch break or whatever it may be, and then we'll be able to come back.
Before we move on to the next violation, I'm going to say one thing about this. I completely agree with all the reasoning that my fellow commissioners have put forth in kind of consideration for responsible party, reduction, classification, and impact. And I think that we're all aligned in kind of what we think went wrong here and the violations associated with it. One thing that I'll set out before I get to this next one, because I think it's important for the way that I'm viewing specifically the determination of classification and impact in both this NOAB that I'm working on and all the other 4 NOABs that are before us here, is that when I review the classification for a rule, I think that's rule specific, right? It goes to the intention of the rule, it goes to the impact of the rule itself. And when I review the impact part of that, I think that is fact specific. And so I'm looking for the actual impact or threats of impact that did or could have or were likely to have occurred at the site when I'm considering what that impact should be. So that's kind of the basis for my suggestion in that regard. And kind of with that, just wanted to throw that out, and I'm going to move on to the 907A violation and walk through my analysis there. So with that, I'll kick that off. So again, with 907A, alleged violation for failure to properly store EMP waste at the Nesu #1 site. I also believe that this contemplates 2 unique alleged violations. So the first alleged violation is the failure to install BMPs, and the second alleged violation is the failure to maintain BMPs. And so when I think about this, I was thinking through the timeline that was presented through the testimony by the witnesses, and this is kind of what I came down on for these various violations. So for the first violation, violation #1, failure to install BMPs. The testimony and the facts that I have in my notes that I found persuasive in looking at this was that there was the November 13th, 2019 inspection of the spill location at Nesu #1. And at that inspection, staff required KPK to install BMPs prior to November 14th, 2019. And those BMPs that were cited were stormwater management and specifically earthen berms surrounding the soil stockpile of impacted soil. The next piece of testimony that I have in my notes, and I think there's a big gap here, is that the staff went out on January 15th, 2020. So November 13th, 2019 to January 15th, 2020. And when they went out on January 15th, 2020, they observed berms around the stockpile, and that in fact those berms had been breached. And I think it's the breaching of those berms that is the failure to maintain the BMPs, which I think is the second violation here. I did not hear any testimony from staff that said that the BMPs and the berms were not installed prior to November 14th, 2019. Because of that, I don't think that staff met its burden to say that KPK violated Rule 907A for failure to install BMPs prior to that November 14th, 2019 date. And in fact, the next piece of testimony, next piece of evidence in my timeline is the January 15th inspection where there were earthen berms. That being said, I think that violation of the failure to install BMPs, again, I don't think staff met their burden and met that element by a preponderance of evidence that failure occurred. And so therefore, that part of the violation, I do not think is appropriate, and that time frame within that violation, I don't think should be considered for this particular rule violation, 907A, in this NOAB. So with that, I'm going to move to violation #2, which is the failure to maintain BMPs. So on that January 15th, 2020 date, staff had received a complaint that the earthen berms around the stockpile had been breached. And I apologize, earlier I said it was the January 15th inspection. It was actually the January 15th complaint that triggered the January 20th inspection by staff to go see and observe those earthen berms around the impacted soil stockpile at the Nesu number 1. And when they did, they in fact observed those berms had been breached. And we heard testimony about that. We saw pictures of it as well. And so staff at that point instructed KPK to repair those BMPs, to repair those earthen berms by January 22nd, 2020. I believe this violation is distinct from the violation alleged that KPK failed to install the berms in November of 2019. The BMPs were still not maintained as April 8th, 2020, and I hear testimony that would suggest that they ever were maintained between that January 22nd date and that April 8th date. And so it is in my estimation that there's been a preponderance of the evidence that that those earthen berms were failed to maintain in violation of Rule 907A between January 22nd and and May 21st, when all the impacted soil was removed and those earthen berms were no longer necessary. So therefore, I think that KPK was in violation of Rule 907A, and the time frame that I believe they were in violation was between those dates of January 22nd and May 21st, 2020. Now, there was testimony that the soil was removed between April 23rd of 2020 and May 21st of 2020, but that the earthen berms, those BMPs still existed. The earthen berms were still failed to be maintained. And I believe that was probably the case if the earthen berms were failed to be maintained all along that time frame, that probably continued until all the soil was removed. So that's the time frame that I'm considering for this particular rule violation. And I won't even endeavor to offer up the math that I came up with for that. But that's kind of where I land in that regard. Now, the statute of limitations was argued in this for this NOAV and for this particular rule violation. I think that given that I don't believe there was a violation for the installation of BMPs in November of 2019, I don't think that we even need to endeavor to consider that statute of limitation violation or statute of limitations for that violation. And the failure to maintain the BMPs, the earthen berms, was well within that statute of limitations. So I feel good moving forward in that regard. I agree with the staff's classification of this rule as a class 2. I believe it has been applied consistently to date, and I don't see any reason to change it. Again, I think classifications are specific to the rule, and I think impact is specific to the circumstances. Here, I also agree with the staff's assessment of a moderate impact level. There were impacted soils there. Those impacted soils tested positive for 910-1 table contaminants. They were on site. They did not have stormwater mitigation in place. I think that just by nature of those impacted soils having the potential to be affected by groundwater or by stormwater, and for those contaminants to move out away from and off that stockpile, I think existed, and I think that justifies that moderate impact level for this violation. And so kind of my next part of the analysis was, are there any mitigating factors to apply? Now, so in this regard, the only mitigating factor that I think is applicable here is the responsible party mitigating factor. And a couple things kind of played into my soon-to-be suggestion on a potential discount for this ultimate penalty. One, again, we talked about it, or I've talked about it already, is the extent of the excavation at Nesu number 1. So the extent of the amount of soil that was pulled, the heavy equipment, the need, and the size of the earthen berm was directly related to the size of the mitigation necessary to not only address KPK's spill, but also the historic spill that KPK discovered and continued to discover, and that excavation kind of continued to grow as they discovered more and more impacts in that underlying soil. Again, I want to completely acknowledge that, these violations are a direct result of KPK's actions. KPK could have kept those berms maintained. They should have done it with the installation timely. They should have done it, maintain it every day when they left site. If those berms were moved for making way for the heavy equipment, as KPK said, there's no reason why those berms shouldn't go up at the end of every day or after they needed to be moved for whatever purpose on the excavation site. I do want to acknowledge that because the excavation site continued to expand, and in the pictures I saw relative to that, the perimeter of that excavation site to the stockpile, it looked like that stockpile got bigger and the excavation site moved closer towards it as it expanded. And I do understand the need for the heavy equipment to be able to move around that stockpile, that stockpile, and to potentially even move those earthen berms to continue to excavate the historic spill that was underneath it. That being said, again, they could have put the berms up every day. They happened to have inspections when the berms were down, and I do believe that there was a failure to maintain those BMPs. But given the extent of the excavation, the need for the heavy equipment, the size of the stockpile, the relative location of the stockpile to the growing excavation site, I do believe there's a mitigating factor that should be applied to specifically the storage of the impacted soil on site. This, is more than definitely more than a paperwork violation, but I also believe that there is more direct impact of the historic spill on KPK's violation or on KPK's action, and therefore I've suggested kind of a 1/3 reduction here, so like a 33 1/3% penalty reduction of the overall penalty for a mitigating factor based on the responsible party for that historic spill. I believe the duration matrix should be applied here, as was done with staff's calculated penalties. So kind of in summation, I suggest finding KPK in violation of Rule 907A. I suggest that violation was for the days as outlined and as noted by either Ms. Larson or Mr. Davenport from January 22nd, 2020 to May 21st, 2020. I think it's a moderate impact in a Class 2 classification, so I agree with both of those. And I suggest a 1/3 or a 33 1/3% discount given the extent of work needed to remediate the historic spill as it related to the size of the stockpile and the heavy equipment moving around the excavation site. And again, the growth of that excavation site as they discovered more contaminated soil within that site. So that is kind of summarizes what I've been thinking and what I've worked through on that second rule violation for Nesu number 1. And I'm happy to entertain any questions and add any clarification anybody needs, because I know that's a lot.
Great. Thank you, Commissioner Gonzalez. Why don't we try to do clarifying questions and then sort of reserve our own thoughts, and we can get back to that after we've taken our lunch break and go back and revisit our notes break. So clarifying questions for Commissioner Gonzalez. Commissioner Messner.
Thank you, Mr. Chair. And thank you for the explanation, Commissioner Gonzalez. That was thoughtful. I was a little unsure. I know you said why, but now I didn't get it in my notes. But why January 22nd instead of January 20th for the start date?
So on January 20th, they observed that the earthen berms had been breached, but were in place, and they gave them until January 22nd to repair those BMPs. And it was the failure to repair those BMPs at that time frame that I thought that's what influenced me to consider that as a start date. Now, I do recognize that failure to maintain BMPs and failure to maintain those earthen berms is a ongoing violation, and that those berms were failed to be maintained on January 20th of 2020. I was working off the deadline date, given the staff gave them an extra couple of days to get those fixed. So it was really the violation, that deadline, that I saw as impactful for that violation. It's my kind of individual reasoning there.
Okay, thanks.
Commissioner McGowan.
Thank you, Mr. Chair. Sorry, I have two questions. One is to follow up on Commissioner Messner's question. So is the 20th though when staff went out and discovered that there was an adequate burn, but then there was a follow-up and the berm had not been? So I'm just trying to follow the date of discovery.
So in my notes from the testimony and from stipulated facts and from the pre-hearing filings, is that the inspection occurred on January 20th, 2020, and that there was a deadline given to repair for January 22nd, 2020.
So in your mind, wouldn't date of discovery be the 20th then when they went out to inspect?
It could very well be. I calculated from the 22nd, just given the staff gave them seemed to have given them some leeway in terms of a couple days to get those repaired. And it was that failure to repair moving forward that I thought was impactful for the date range that I'm suggesting.
Thank you. So my other question, I have some notes that I took also related to appropriate fencing as part of BMPs, and I'm kind of struggling to make the connection with the earth that was being stored versus the fencing around the big hole, and whether or not these are all connected or are separate. And I'm wondering if you have some thoughts.
So when I was thinking, so I do recall the testimony about the fencing around the excavation site. I didn't think that was impactful, or that was specifically tied to 907A, and the elements of 907A is the failure to properly store EMP waste to prevent environmental impacts. And that was the earth and berm BMPs that I recall from testimony. And that's why I've kind of limited my analysis to the installation of those earthen berms, and then later to the subsequent maintenance of those earthen berms.
Any further clarifying questions at this time? Commissioner Nanjapa?
Thank you, Mr. Chair. And yeah, thank you, Commissioner Gonzalez. I appreciate the analysis on this one. And just so that I'm clear too, because you are saying that the initial violation of the failure to install does not apply, you are considering the statute of limitations from the January 15th complaint. Is that correct? January 15th, 2020 complaint that was submitted, and then the inspection, or at least the 20th inspection by the staff?
For the installation of the berms, I didn't get to a statute of limitations analysis because I think that there was not testimony enough to meet staff's burden of proving the violation of the failure to install on that November 14th deadline. And in fact, the kind of next piece of testimony in the timeline was January 20th, and there were in fact berms around the stockpile there. And that's kind of when that second BMP, that failure to maintain, was the trigger for me for what an appropriate violation of this rule was.
Okay, thank you. Yeah, sorry, that I did, yeah. So understanding that first violation you believe did not occur because we don't really have evidence to support that there weren't berms installed because there was not an inspection in that interim period. The second violation of the failure to maintain, you are saying the start date is January 22nd, based on what you were explaining to Commissioner McGowan's question. But that's also the date that you're considering for the statute of limitations with respect to the serving of the NOAV. Is that correct?
Well, the NOAV was served on December 10th of 2020. And so whether it was January 20th inspection day or the January 22nd deadline, I think both of those are well within that statute of limitations. So I didn't even endeavor to consider anything beyond that.
Okay, thank you. I was thinking, yeah, no, understood. Because you're considering this as this is a separate violation that's being contemplated within. So as for this particular violation of the failure to maintain,
that's how I see it.
Okay, got it. Thank you. Appreciate that.
Any further clarifying questions? All right, seeing none, thank you, Commissioner Gonzalez, for the presentations. Thank you, commissioners, for your clarifying questions. I'll let everybody go take a lunch break and review notes. Let's return at 12:50, which is about 45-ish minutes or so. Okay, commissioners, we've had our lunch break and our break to go back and review our notes. We had our presentation from Commissioner Gonzalez, and we're now back to allow other commissioners to weigh in on their thoughts relevant to the Nesu 1, which is the first one we're taking up. So does anyone desire to go first with thoughts? Commissioner Nanjapa.
Thank you, Mr. Chair. And again, I want to thank Commissioner Gonzalez for putting out the information and thinking through everything very carefully. I appreciate all the explanations that you provided. After reviewing the classification matrix, I think I agree with some of the discussion that we had just before the break, that while this is related to forms and form submission, the form being submitted is the initiation of a dialogue. And ostensibly, if that dialogue had occurred, we might not even be discussing the 907A violation. And so I believe that this should remain a class 2 moderate, given the potential, given the threat of impact, because of the failure to provide the form in a timely manner and receive the guidance that they could have received to be able to do the right thing or do the remediation appropriately. And so I believe that is what we need to continue with as initially proposed, and specifically for those dates of the supplemental being late, supplemental form 27 from February 4th through April 15th. Should I also discuss 907A, Mr. Chair?
Sure. Why don't we do it that way? That way we can get thoughts, because I think we're all kind of looking at this in toto.
Okay. And so then looking at 907A, I agree with Commissioner Gonzalez's assessment that the staff did not meet their burden, that there was a failure to install the BMPs. We do not know that for sure. However, I do believe that we have evidence to support that they were not maintained. And as Commissioner Gonzalez stated, those berms, even if they had to be moved and taken down for the purposes of the excavation, could have been restored at the end of each day. And so I believe that the failure to maintain that violation does hold up, and that the staff has met its burden to demonstrate that. And I'm a little bit, the only thing I'm a little bit uncertain is the start date with respect to the questions that Commissioner McGowan was asking. The date of discovery was January 20th upon inspection. And while they were given a couple of days to correct it, I think based on what we are discussing in other matters, the date of discovery does matter here. All that said, I do believe that there should be a credit for doing the right thing for upon discovery of the historic contamination, the additional cleanup that they did. So I am of the opinion that we do not offer a discount on the 901C violation, but we do offer a discount on the 907A violation. And I would support the suggestion of the 1/3 or so as proposed from Commissioner Gonzalez.
Great. Thank you, Commissioner Nanjapa. Commissioner McGowan, then Commissioner Messner.
Thank you, Mr. Chair. And I'm just going to support everything that Commissioner Nanjapa said, and thank you, Commissioner Gonzalez, for putting this all together so succinctly. I do also agree and want to support changing that start date to the date of discovery, which is the 1/20/2020. And I support all the other things, no reduction for the 901C, a moderate penalty, and a reduction for the 907A.
Thank you, Commissioner McGowan. Commissioner Messner.
Thank you, Mr. Chair. And thank you, Commissioner Joppa. I think that is a logical conclusion. It's along the same lines generally as where I was going to go. I was going to propose a 20% reduction for both 901C and 907A. I see some advantages of just consolidating that into a third reduction. in 907A, so I can concur with that. I think that does create a benefit for the actions that were taken, and probably is a more appropriate place to apply a discount instead of 901C. I do think 901C needs to stay as a class 2 moderate, and will agree with the January 20th start date.
Thank you, Commissioner Messner. I'll add my me too to what has been suggested. I was likewise, Commissioner Messner, thinking about reducing the 33 down to 20, but reducing the other to 0 is good with me. The only other piece that I would like to speak to, though, is the the stating that there was not a failure to create best management practices around the initial construction. And bear with me, I just kind of want to walk through this and see what folks are thinking. But my notes reflect that initial construction started on 10/21, and that on 11/13, Mr. McLaren went out and found a lack of BMPs. I will look to my notes real quick. That I thought that Mr. McLaren went out and failed to find, hold on. Berms, fences, berms to stop run-on from the uphill side, berms to stop runoff on the downhill side. And there was a track hole on site, moving dirt around, no barriers under it, no berms at all, et cetera. Now, realizing that there was then the COA to get all that fixed, and then they didn't go back out and recheck until the 20th of January, if my days are right, we don't have an ability to confirm whether the berms were installed by the COA on the next day. But I do think we have evidence necessary to find a one-day penalty for the day that they did find the BMPs were not installed. Having said that, the NOAV for this was issued on 12/10/2020, and therefore I find that one-day penalty to be barred by the applicable statute of limitations. But I think it's important for us to create a record as we're looking at all of the various NOAVs in terms of, I think there's a distinction with the difference if it was a one-day violation that was time barred, which is what I find, versus not making that finding at all. So I wonder if other commissioners have thoughts about that line of thinking. Commissioner Messner.
Thank you, Mr. Chair. I concur with you. I didn't go there just because I knew that it was time barred. But I do have in my notes that there was actually a violation outside of the statute of limitations. So I can concur with your analysis.
Any others to weigh in? Okay, well, I'm not seeing others weighing in one way or another around that, but the record is reflected from at least two of us on that point. Yeah. And so AAG Davenport is going to make changes consistent with what we just heard. And I don't know that we need a vote. I think that four of us seem to be consistent with regard to where we would like this to land. So with that, do we want to give Kyle a second to make his changes, and then we can make sure we're in agreement before we move on? Commissioner Messner?
Thank you, Mr. Chair. I mean, if we want to give Kyle a little time, we could move on to the next item and then come back to this to take a look at it. I don't know how long it's going to take him, but.
I'm going to ask AG Davenport. I know you like to take notes as we're deliberating, so I don't want to make you do two things at once. What do you want to do?
I think I can do it pretty quickly if the commissioners will indulge me for just a couple more minutes. And one thing that I am not clear on is we are deleting the 20% reduction for the 901C.
Yeah,
Is that accurate?
and leaving the other one at 33.34.
Okay. And commissioners, I'll just represent you. We will go back and check our math and make sure that's all accurate after the fact, but I would like to give you an opportunity to just see what it appears likely to be.
Is that right?
Well, I shouldn't have deleted the 5,000. That's
Okay.
staying where it is. Let's see here, 33. 20.
Mimi, yes, he's counting you.
That's what we're looking at.
Although you- Okay, commissioners, I think we now have on the page what is consistent with where a majority of us are finding ourselves. All right. Seeing nothing further, Commissioner Nanjapa, I believe you have the floor for the Nesu Consolidated Flow Line.
Thank you, Mr. Chair. 1 second and I'll pull up my notes here. Okay, so the Nesu Consolidated Flow Line, this is NOAV number 4025-48397. We issued the NOAV on January 12th of 2021. The site was investigated following a complaint from the landowner on January 13th of 2020. And our COGCC staff went out on January 14th of 2020 to inspect. At that time, so there are two violations, rule violations at issue. One is 901C, which was similar to the previous NOAV that we just discussed, a failure to submit the Form 27, which is the site investigation and remediation work plan by March 2nd of 2020. The second violation is Rule 906B1A, which was a failure to report a spill in a timely manner, and specifically a spill that of any size that impacts or threatens to impact any waters of the state, residents or occupied structure, livestock, or public byway. And in this case, I believe what is particularly at issue is the waters of the state. With respect to 901C, I believe that the statute of limitations does not apply because the discovery of the alleged violation occurred on January 14th on our staff's inspection, and the NOAV was served on January 12th, 2021, so within a year. However, with respect to determination of a penalty, we have, at least from the landowner, from the reports from KPK, when the spill report was completed, that it was that it occurred around November 1st, or November 1st was the date that was used, November 1st, 2019. There was some discussion with respect to the impacts of COVID, but apart from that, it was around January 17th when a corrected flow line sketch was provided to COGCC that a condition of approval was given for the Form 27 to be submitted by March 2nd. And by my count, that was approximately 44 days to prepare that, that Form 27. And last year was a leap year, so we had 29 days in February. So, as far as I can tell, you know, there was a reasonable amount of time to prepare that Form 27. And according to testimony and some of our questions, you know, we noted that a couple of different commissioners noted that the first COVID was reported in Colorado on March 5th, but there was some testimony that there were preparations that were occurring within KPK prior to that. However, there were no communications on record to COGCC with respect to the concern about COVID impacting their ability to prepare the form, and no requests for extensions. And so in light of that, and in light of this being a spill that even upon the January 14th inspection, there were soil staining that was observed and hydrocarbon odor that was observed, that I believe the classification of this as a Class 2 moderate violation is appropriate. And I believe that the days as proposed by staff, the dates from March 3rd through the submission of the form, the actual submission of the form on April 9th, 2020, and again, without any communication about a reason for a potential delay even after March 2nd or after March 5th when COVID was first reported, or after the stay-at-home orders were issued for the state of Colorado. There was no communications with respect to concerns about ability to prepare the form, so I believe that full period should remain as proposed by staff. Mr. Chair, should I continue with this subsequent violation, or should we just stop here and allow for some questions or discussion?
Comfortable continuing. What do other folks think? We did it last time. Yeah, I think you're getting nods to go ahead.
Okay. With respect to 906B1A, again, this is related to the reporting of the spill in a timely manner, and particularly a spill that of any size that impacts or threatens to impact the waters of the state. I don't believe we had any evidence in testimony that questioned or gave us reason to believe that this was a large spill or greater than a barrel in size. At the time of the inspection, we do not have reason to believe that irrigation was occurring, though we know that this was a field that was irrigated. At the time that KPK noted that the landowner reported to them of the spill as November 1st, I don't believe we have any testimony to suggest that there was irrigation occurring at that time. However, we also heard testimony that there was no flow in the line because the whole system was shut down in relation to the previous matter that we just discussed, that Commissioner Gonzalez presented. And based on that, the self-report occurred on October 18th, but in relation to that and to the documentation that we have, I believe it was in particular the Form 19 supplemental, it notes, and KPK, I believe, prepared this form, it notes that the system was shut down on October 16th upon the discovery of the spill, because the land was being irrigated. So we at least know or have reason to believe that the land was being irrigated on October 16th and that the flow was shut down after that. So my thought process and my sort of logic train that I'm following here is that although there may not have been irrigation at the time of the report by the landowner or the report or the investigation, sorry, by COGCC staff, that it is reasonable to conclude that that spill, given that we know it was a small flow line, low pressure flow line, it was a small crack, it was what we heard from the testimony, but it had daylighted 4 feet above ground. So that spill probably occurred sometime prior to November 1 for it to have been daylighted. And we at least know that the field was irrigated on October 16. So for purposes of classification, I would agree with the staff's classification of this as a class 2, although I would even propose that we consider it as a class 2 moderate because of the threat to the waters of the state, given that it is, I believe, it is reasonable to conclude that the spill occurred when the land was being irrigated at least October 16th. And so I also believe that for penalty calculation, we might consider using the October 16th date, given that the flow line was not only shut down, but blown down at that time. And so if there was any residual material in the line, I think it's reasonable to conclude it would be a small amount. And that small amount is, it's probably reasonable to conclude that that small amount could not spill out and also daylight within that time frame. So that is my presentation of the evidence and my thought process with respect to the classification. And I would be happy to discuss further at this point.
Thank you, Commissioner Nanjapa. Do folks have clarifying questions before we take a short break to look at our notes? Commissioner McGowan.
Thank you, Mr. Chair, and thank you, Commissioner Nanjapa, for putting this all together for us. For waters of the state, it's interesting to me that we're discussing whether or not it was being irrigated at the time, because we only have to show that it is defined as a water of the state, not that there's actually water running through it, correct?
Commissioner McGowan, I'm not sure, are you, what would be defined as a water of the state in your question?
So if during mission change, when we were talking about waters of the state, we talked about intermittent streams, ephemeral streams, places where water sometimes is or is not. If a spill were to occur, but for example, an intermittent stream or an ephemeral stream was dry at the time, is it not a spill into the waters of the state, or is that still considered a spill into waters of the state? Does there have to be water in said location if the geographic location is defined as a water of the state? So if someone's irrigated property is defined as a water of the state, does water have to be running in it at the time of the violation? We seem to be concerned whether or not irrigation actually happened, and I'm saying I'm not sure that has to actually be the bar.
Okay, thank you, Commissioner McGowan. I think I understand what you're saying. I guess I'm saying something slightly different.
Okay.
And there are waters of the state or mapped wetlands adjacent to the property.
Yes.
And so my thought process is that if that spill was present while the land was being irrigated, then there is a threat to the waters of the state. And so that is why I believe it's a class 2 and a moderate impact because of the threat of significant adverse impacts, or the way the classification matrix states is a moderate impact would be a threat with significant adverse impacts or moderate actual adverse impacts. I don't believe we have evidence of actual impacts, but I do believe that there is a threat of significant adverse impacts. A separate matter that I don't believe is material per se here is that if the landowner had not reported it, or sorry, if we had not received the complaint on January 13th, my understanding of the testimony and the evidence is that there had not been remediation activities that had occurred prior, and therefore, you know, this is there was an ongoing threat, in my view.
Thank you. Thanks for clarifying that.
Commissioner Gonzalez, then Commissioner Messner.
Thank you, Chair, and thank you, Commissioner Nanjapa, for the presentation. I think that hit on a lot of the pivotal points that I was thinking about. So one clarification, I just want to make sure that I get this clarified. This has nothing to do with what I'm about to say, but I don't think the spill was self-reported. I think they reported by direction of the COGCC subsequent to the inspection and the complaint that occurred. So that's something that I heard in testimony. I'm not quite, I think that's the way I understood it.
Can I clarify, or I'll let you finish, go ahead.
Oh, no, I mean that you're welcome to clarify, and I'll go on to my next statement.
Okay, sorry, what I was referring to was the self-reporting of the Nesu 1 matter, which occurred on October 18th. And according to the supplemental spill form that was filed for that matter, there was language in that spill report that the lines were shut down immediately and blown down because the land was being irrigated. So that's the self-report I was discussing, but yes, you are correct, and I agree with you that the report occurred by the landowner on about November 1st, and then we had the inspection on January 14th following a complaint on the 13th. Perfect. Thank you for that clarification. That was my confusion, listening to kind of the recitation of facts, which is all sometimes a blur with everything that we're timelining here. So my next question is about kind of the impact of the irrigation into the waters of the state. Or as a water of the state. And I think I don't have an issue that if there's irrigated water, that would be waters of the state. But I'm curious about if the spill hadn't one thing that I'm thinking about, let me say this. One thing that I'm thinking about is if the spill hadn't daylighted until after the irrigation was done, the presence of the spill and its migration from the underground flow line to the surface, if that's what is kind of the pivotal piece for determining the threat to the waters of the state. Let me make sure that I'm understanding, Commissioner Gonzalez. So you're saying there's a question about whether the spill for this particular matter was daylighted ahead of November 1st, or whether we know that. Or if daylighting matters to the threat of to water to the state. What I'm getting at is I'm not quite sure that I heard testimony that it had daylighted and that in fact it's daylighting given the prior irrigation was the threat to the waters of the state. And I'm trying to understand if that's what, you know, kind of in your analysis, that's what ties to the threat to the waters of the state is the migration of the underground spill between whenever the well was shut in or was flowing until November 1st, 2019. And if that underground part prior to daylighting was the threat to the waters of the state. I'm just trying to understand kind of the analysis here. I think that's possible, but I think what I was suggesting is that given that the lines were shut down and that there may be some residual matter in the lines, I think it's difficult for me to conclude that it's that residual matter in the line that spilled and also daylighted after October 16th when the lines were shut down. So my reasonable conclusion is that that spill began before the lines were shut down in order for it to have daylighted by November 1st when the landowner observed it.
Okay.
Does that make sense?
Yeah, that makes sense. That kind of clears up. I'm just trying to understand, kind of what's leading to this conclusion. Make sure I understand all the points before I give it some thought with my notes. So thank you for that.
Commissioner Messner?
Thank you, Mr. Chair. And thank you, Commissioner Nanjapa, for going over all those facts. I mean, I thought it was a thoughtful analysis. I think I've got a couple of things to add. Just to clarify, I think where you're going with this is that the complainant, right? So the landowner indicated the leak in his complaint that was submitted to the COGCC. He actually indicated that the leak occurred in May of 2019. And that in his irrigated cornfield, that there was no corn growth occurring through the 2019 growing season due to hydrocarbon impacted soil, or what he was calling a leak. So growing season April to September at a minimum. So I think that where you're going is a similar place to where I went as far as where the facts brought me to a reasonable conclusion. But I think it's important to also show that the complainant actually indicated that there was leaking occurring during the irrigation season.
Thank you, Commissioner Messner. Yeah, and I did note that in the complaint. However, in my thought process, because there was not a complaint in May to COGCC, we can't say for certain that that occurred. We have, as far as I understand, there was not a separate complaint prior to the one that we received on January 13th from this landowner regarding the damage to the crops or the presence of the spill, et cetera.
So
is that your understanding? Sorry.
Well, I'm actually, this is from that complaint where the landowner complained about activities and impacts that were occurring as far back as May. And I've got, and I'll pull it up during our break, but there was an exhibit provided that showed that. So.
Okay, thank you, Commissioner. No, I agree. I agree that that is, we have that in the record, and that the complaint on January 13th indicates that this has been ongoing since May. And I would agree that if that is correct, that I would believe that then that means that through the entire growing season, essentially the field was irrigated, and that this is a threat to the waters of the state, if that is correct. What I was hesitating on is as it relates to the dates of violation for the purposes of penalty calculation, and what we can really use as the sort of starting point. So I agree with you that we at least have some evidence or some suggestion that this occurred prior to that, but I think I was more kind of leaning on, what we know with more certainty with respect to the timing of at least on October 16th when the lines were shut down.
I agree with that,
you.
stating that to determine that there was a potential threat to the threat of impact to waters of the state, and so therefore it was a reportable offense. That's it, not for a penalty calculation.
Okay.
Commissioner McGowan?
Thank you, Mr. Chair. Commissioner Mesner, are you talking about, so I just want to clarify for myself, the exhibit from Mr., I know I'm going to pronounce the name wrong, Hadley, that he submitted, and was it the actual complaint or was that his public comment? Or were we talking about two different things? Am I confusing things?
This is the actual complaint that
The
he
actual
made to
complaint.
COGCC, formal
Okay.
complaint.
Thank you.
This is exhibit number 200 in the staff's materials. Yeah.
Any other clarifications? Do we want to take a short break? Just keep moving? Go ahead, Commissioner Messner, give us your comments.
You want me to give you my comments? So I agree with Commissioner Nanjapa in her analysis, and I would, I would state that, this was a reportable release. The complainant indicated the leak occurred around May 2019. The first complaint to KPK was on November 1st, 2019. It was an irrigated cornfield. The complainant indicated that there was no corn growth through the growing season, April to September. The complaint didn't indicate when the growing season was. I'm implying that. Irrigated water is waters of the state. The leak threatened waters of the state. Staff did not find out about the leak until January 14th, 2020. It's regulator day of discovery. This is within the statute of limitations. So I would agree with the conclusions. I do believe it's a class 2 moderate classification for 906B1A. And I do agree with Commissioner Nanjapa's conclusions as to 901C.
Commissioner Gonzalez?
Okay, so as to 901C, I agree with the analysis. I agree with staff's recommended penalty, classification, impact, and days of violation. So I'm good on 901C as written, as alleged. I've struggled. I continue to struggle with waters of the state and how we apply it. Going back, I've read that definition 4 or 5 times, maybe more, who knows. The way that definition contemplates waters of the state or the potential impact, I mean, it could be anything. It is a very, very broad definition. And I think given that, I think it's important for operators to consider that and to really engage with staff on what could or couldn't, may or may not be waters of the state. That being said, another part of this is that a lot of what we're using to define waters of the state is the status of it being an irrigated field at the time that the spill could have impacted the water used in that irrigation. And I would have loved to hear from Mr. Hladky as a witness. All we have is what Mr. Hladky has said in his complaint, and it's up to us to assign credibility to that. And I have no reason to believe that Mr. Hladky would not be 100% forthright. That being said, I think that the respondent should have had the opportunity to ask him questions and to put forth their claim that way. Where I struggle is at the time that the spill was daylighted, as far as we know, was November 1st, 2019. And that's the date that staff and the operator seemed to have agreed on when it was most likely to have daylight and to have occurred and to have put the operator on notice. At the time, there was no irrigation. And so in that regard, and with the spill being less than a barrel release, I have a hard time associating that with it being a waters of the state. I guess using waters of the state as a trigger for the impact here. I think that that the analysis from Commissioner Nanjapa about the potential migration from what could have been an ongoing spill or a spill associated with the Nesu Consolidated line prior to the shut-in of the Nesu number 1 or the lines associated with the Nesu number 1 cleanup is impactful. But I think that if I'm thinking about this in the pure terms of threats to waters of the state as being the trigger for this being a reportable spill, I wouldn't think that those would be impacted until the actual substances daylighted to the surface, at which point irrigation water would have run across them and potentially into the irrigation ditch, and then would have been definitely a threat or a direct impact to waters of the state. So where I'm landing right now, and I've been struggling on this, and I'm not quite sure that I've landed anywhere from my thoughts over the weekend, my thoughts this morning about it, the deliberations here, but I don't feel when it comes down to it that staff has proven to me as one commissioner by a preponderance of the evidence that in fact there was a threat to waters of the state as a result of this spill. And that's kind of the crux at which I'm leaning on right now, or the crux in which I think that this whole thing pivots for me. If I was finding that it was an impact to the waters of the state, I would agree with Commissioner Nanjapa's assessment of the moderate impact or the moderate threat. I think any threat to irrigation water going into a communal irrigation ditch that I believe was a short distance away from this spill location would have definitely merited that impact level. But where I stand now, I do not think that staff has met the burden as to the element of the impact to waters of the state or the threat to waters of the state. And it certainly didn't meet it on the size of the spill being another trigger under the 906B rule. So that's where I'm landing on it. And it's just that's my 2 cents.
Commissioner McGowan?
Thank you, Mr. Chair. I guess I've been struggling with that whole piece as well. I think that there are some compelling photos that were introduced by staff as part of their presentation, that the staining definitely made it to the surface. I think it's really difficult to tell what the size was, or that anybody actually knows the exact size of the spill. And, in addition to whether irrigation happened, I think if I'm recalling correctly, I think staff made also the point that, rain and snowfall are also other ways and pathways for contamination to migrate off site. So I'm kind of taking that into consideration as well.
Commissioner Messner?
Thank you, Mr. Chair. I would also point out from this commissioner's perspective that this was a flood irrigated field, and flood irrigation, from experience, is a very different type of irrigation with different characteristics for the potential to carry hydrocarbons or things that would threaten waters of the state than a sprinkler-based irrigation system. So I would have a different opinion if this was a sprinkler-based irrigation system, but it is not. It's a flood-irrigated system, and so to me, the direct impact of hydrocarbons to the irrigation water itself and the volume of irrigation water associated with flood-irrigated field is a big factor for me.
Commissioner Nanjapa?
Thank you, Mr. Chair. And thank you, Commissioner Messner. I neglected to note that point. And yeah, I agree that this is tricky, and I really thought through a bunch of the different factors there, but that was a factor for me, the flood irrigation, as well as, the idea that simply because the land was dry at the time of the report and the time of inspection does not preclude a threat to the waters of the state, given that it occurs on irrigated land and given what we knew at least on October 16th. And so, so yeah, I do think those factors do make a difference in the potential threat to the waters of the state.
Commissioner Najapa or Commissioner Messner, what are your thoughts relative to the start date? If this has been proved up. Commissioner Messner?
So I've got a start date of November 1st, 2019 for the, sorry, I've got a start date of November 2nd, as there was 24 hours between initial notification and the requirement to submit a Form 19. So November 2nd is the start date that I have on the 906B1A. As far as the 901C, I just agree with staff's recommendation on that, which is the start date of 3/3 to 4/9.
Commissioner Najapa?
Thank you, Mr.
Thank you.
Chair. And we do have the report showing November 1st as the start date. However, what I was mentioning before with the lines having been shut down on October 16th, I think it's reasonable to conclude that the spill occurred prior to at least that date. And so that's where I was suggesting October 16th.
Sorry, Mr. Chair.
Commissioner McGowan?
I was trying to reread the stipulated facts. Sorry, Commissioner Joppa, can you please explain how the event that happened on the 16th that led you to the start date of the 16th, or is?
Yeah, so we heard in testimony related to the Nesu consolidated flow line that there wasn't even anything flowing through the pipelines, on the date of inspection on January 14th, nor prior when the landowner reported it, because back in October, that whole Nesu system was shut down because of the Nesu 1 matter. That was the one, so in the separate NOAV that we just previously discussed, in those exhibits, there is information about that, when that was shut down. And
The
that
shutdown date.
Yes.
Okay, thank you. Thank you.
I'd like to take 5 minutes and look at my notes. Well, frankly, looking back at my notes didn't really help me. I think I am in agreement with Commissioner Gonzalez, though. And I think it's because I don't believe that we have developed facts sufficient to determine when, how, where the spill occurred. And I don't know that I've got facts sufficient, for me at least, that even implicitly the spill occurred at a time when the irrigation may or may not have occurred. I just don't, there's not a, and as a result, I would have loved to have heard from the landowner. I would have loved to have heard from several other witnesses, but they're not here before us. And staff has the burden of proof. And as a result, I don't believe that I can make a finding that that was a reportable event for a spill to waters of the state. I'm in agreement with everyone else on 901C. Commissioner Messner?
So just a point of clarification, 901C does not happen without 906B1A, right?
Commissioner Gonzalez?
Yeah, so I can kind of tell you how I landed on 901C being appropriate, right? 901A or 906B is the need for reporting of a spill. Now, there's debate as to whether or not it need to be reported, but the 901C is specific to a director may issue requirements to protect anything, basically to protect against contamination under the 910-1. So regardless of whether or not it was reportable, when the director issued to KPK additional requirements and they failed to meet that, I thought that that was impactful to me on why 901C is a violation independent of a finding of a reportable spill for 906B. So that's just my, kind of independent view on that.
Makes sense. I appreciate that clarification. For the record, I still am where I was before the break.
Okay, great. Commissioner McGowan?
I think I'm leaning towards Commissioner Robbins and Gonzalez's point, which is I just am unsure how big that spill was. Even staff's own testimony implies that it wasn't really big. And so was there an actual threat or impact or threat to waters of the state or even the residents that was nearby? And I'm not sure. Because we can't include the residence or occupied structure which was nearby, as was his water well.
Commissioner Nanjapa?
Thank you, Mr. Chair. I think, yeah, I appreciate Commissioner Gonzalez clarifying on 901C, and I agree completely that I think, upon investigation from the complaint on January 13th, there's always the opportunity for COGCC staff to issue conditions of approval, and require certain things to be submitted. And so I think, we heard that it is the obligation of any operator to clean up any spill. And this was part of my thinking, is that had that complaint not occurred, and had that investigation not occurred, we would still have hydrocarbons on the landscape. And to me, that in itself, given the fact that the field is irrigated and again, thinking also backwards in the time frame, that I do believe that there is a potential threat of those hydrocarbons being transported. I understand the difficulty with this one. I think it's very there's a lot of different pieces here, but specifically if there is a threat to waters of the state, it's for a spill of any size. So it doesn't matter how big it is. And I think that upon seeing it, the staff saw obviously that there was at least some remediation that needed to occur there. And those things did not occur until after the staff had been there. And that was sometime in the spring, and there was additional conversations with the landowner at that time, coordinating the schedule and all those kinds of things. And so those are the other pieces that factored in for me.
Thank you, Commissioner Nanjapa, for that explanation. Commissioner McGowan?
Yeah, I'm appreciative of that too. Now that I'm rereading language, it's a spill of any size that can impact. So it doesn't matter if it's a drop or 5 gallons or 150 barrels. So I see what you're saying, Commissioner Nanjapa. Thank you.
Commissioner Gonzalez?
Yeah, and to kind of piggyback on that point from Commissioner Nanjapa, I think regardless of my, landing on a point where I don't think staff met their burden, right? And that's kind of the job that I see that I have as an arbiter of this matter. It doesn't sound like KPK did a really good job at all in terms of addressing a spill of any size, reportable or otherwise, and cleaning it up and working with the landowner and doing it timely and coming in from the access road that they wanted them to, and to do it with appropriate notice and to not string them along. And I think that they failed in all those regards. And I hope that this is not, one of those issues where, we're letting anyone off the hook. For me, it's just a matter of looking at the facts, looking at the burden, and seeing what was met, and that's kind of where I landed on it. But I agree, all those considerations about the operator's actions in this regard definitely weighed on me in considering this matter.
I agree with those thoughts and comments, Commissioner Gonzalez. Commissioner Messner?
Just for the record, this commissioner is still where he was before the break.
Thank you for your consistency, Commissioner Messner. Yeah, why don't you do that?
Mr. Chair.
AG Davenport.
Thank you, Mr. Chair. I'm having a hard time finding my button to turn my camera on, so I won't delay proceedings any further. Commissioners, in my effort to record your deliberations on the table that you see, I am not sure where everyone is as to whether or not there was a violation of 906B at all. I know some commissioners, I think, but it would help me if we could start there and get everyone's decision on whether or not there was a violation of 906B at all.
Commissioner McGowan?
Thank you, Mr. Chair. I think the other thing that's playing into my thoughts about this too has been testimony over the last couple of days from staff, where it is common for most operators, regardless of the size of the spill, to report, because you don't know sometimes what you don't know. And the fact that the landowner finally complained because he felt that there was a lack of action on the operator's part in dealing with the spill indicates to me that had there been action earlier and an appropriate report of spilling, back to our discussion of, there could have been a dialogue with our staff on how to address it and how to take care of this spill. And so I'm going to lean toward the right thing for the operator to do should have been to exercise caution and err on the side of, I'm going to report it because it happened, just to cover my bases and start a dialogue with staff. And I think that there has been a violation.
And AG Davenport, I think that Commissioners Nanjapa and Commissioner Messner would agree with that.
That's what I have in my notes.
Okay.
So we have at least 3 commissioners
And
finding a violation.
I still am not sure that a violation has been proved up, but I agree with everything that Commissioner McGowan just said. Throughout my notes on all of these, the course of action this operator has demonstrated, which is a non-dialogue course of action, a non-filing course of action, a non-work with COGC staff course of action, is very troubling to me. So while I may not find a specific violation, the theme that I'm seeing continues to disturb me, and it's not what I believe is proper business practices in the state of Colorado. Commissioner Gonzalez, I think you had your hand raised.
Sure. Yeah, no, I echo that, Mr. Chair. And I am not finding a violation of 906B on the sole basis that I don't think staff proved that there, well, obviously it wasn't big enough. And I think that was testimony that came from both sides. Definitely no one was trying to make the case that it was big enough to be reportable on a size basis. And for me, I don't think the staff proved to me beyond a preponderance of the evidence that in fact there was a threat to water to the state for this spill. And so on that basis alone, I don't think that I can find a violation here of 906B. But again, just a series of what seems like just kind of poor operations all around that I would like to see differently. I'd like to see other operators do it differently. I would love it if operators would err on the side of being conservative and engage with staff on how to report spills and the identification of reportable spills going forward. So that's, Kyle, for your notes, that's where I'm sitting on it.
Mr. Chair, can we, sorry, I feel like I can't make a decision right now. I think there's compelling arguments here on both sides. And so if I'm the swing vote, I'm not gonna be able to decide right this moment on this. Sorry.
That it's not a problem. I told you earlier that we do not take apologies for the work that we're doing. Would you like to stay consideration of this and move into hearing from our next commissioner on the next one, and then maybe at the end of the day we can circle back and make a determination?
Yeah, just on the 906B, I'm fine with the 901C as with all the other commissioners.
Okay. Are other commissioners okay with that? Okay. I forgot who's next.
I think it's John.
Good. I was hoping it wasn't going to be Karen. Okay, John, you're up next. No, because I want you to be thinking about the other one too. Okay, Commissioner Messner, I think you are now up with the UPR Pan Am 1.
Thank you, Mr. Chair. If it's okay with the other commissioners, I'm going to read through my thoughts on all of the alleged violations, and then we can go back and look at them individually. But these things all tie together a little bit, so I think it's important to get a broad overview of all of them because there is a number of them. So with that, this is UPRR Pan Am Consolidated. I'll start with Rule 1102I2. So Rule 1102I2 clearly indicates that whenever an operator discovers any condition that could adversely affect the safe and proper operation of a flow line or crude oil transfer line, the operator must correct the condition as soon as possible. In this instance, the operator, upon receipt of information from the landowner on September 19th, 2019, that there was a leak or release, closed 2 isolation valves and utilized a vacuum truck to depressurize the line and remove any fluids or gas left in the line. This was most likely on September 19th, based on testimony from KPK staff, Mr. Peterson and Mr. Knopp, though there have been no clear logs or records of this provided, and both Mr. Peterson and Mr. Knopp seem to have a hard time recollecting the timelines associated. It also appears that the operator began excavating to expose the flow line and stockpiling soil from the leak area on September 19th, as indicated by testimony from Mr. Knopp and Mr. Peterson. According to testimony, there was no further action taken at the site from September 19th until September 23rd, at which time Mr. Peterson indicated that action to repair the line began in the morning, which included excavation on the line from the other side of the road to expose the same flow line in order to place poly pipe in the line as a repair action. Staff from COGCC arrived on site later in the day on September 23rd and found a grade 1 gas leak that threatened or impacted waters of the state, a residence or occupied structure, and a public byway. Staff instructed KPK to immediately correct the situation, amongst other things. That day, September 23rd, KPK utilized a vacuum truck to depressurize the line, but took no further actions. KPK over the next few days installed temporary isolation valves and began a repair by inserting polypipe into the line. A picture shown by Mr. Jacobs in testimony of Mr. Peterson showed a timestamp picture from September 28th on the excavation on the other side of the road, clearly showing polypipe being inserted into the active repair site. According to testimony by both Mr. Knopp and Mr. Silva, there was another pressurization event on October 1st due to an issue with the same isolation valves that had been attempted to be fixed. It is not clear to me that even to today's date that the issue has been corrected. I find this a clear violation of Rule 1102I2 in that the operator did not correct the condition as soon as possible. I note the rule states that the operator must correct, not attempt to correct or begin correction activities, but actually correct the condition that could adversely affect safety. I would also conclude that while this violation could very well have begun on September 19th, as KPK staff attempted to correct on this date, it has clearly been shown that they did not actually correct the issue on this date, and KPK staff failed to follow up on the attempted corrective action at any time between September 19th and September 23rd, when staff observed the failed corrective action. The fact that staff used the September 23rd date to begin the violation is generous. In addition, since it was testified by KPK witnesses that in fact this corrective action was indeed not successful, as indicated by another repressurization on October 1st, that the end date that staff is using for this violation, for the violation penalty, September 25th, is also generous. Nonetheless, I will agree with staff's determination of penalty dates, classifications, and penalties requested as presented. For Rule 1102J1, this rule indicates that each operator must make repairs in a safe manner that prevents injury to persons and damage to equipment and property. In this instance, KPK staff indicated through testimony that they began repairs and corrective activity as early as September 19th, but again on the morning of September 23rd, and again while COGCC staff was present later in the day on September 23rd. Even though KPK staff were utilizing a different excavation site to attempt repairs to the affected area, the flow line on which they were working was in fact the same flow line that had the leak and was not depressurized due to the issue with the isolation valve or isolation gate valve. KPK staff did not confirm that the line was depressurized, nor did they notice the active grade 1 gas leak the morning that they began activities. In addition, even though other KPK staff were informed that COGCC staff had found a grade 1 gas leak, KPK staff failed to inform the roustabout crews to stay away from the site as they arrived on site and began unloading pipe per COGCC staff testimony. This pipe, according to the manufacturer's specification, had the ability to create static sparks, was being unloaded downwind of the grade 1 gas leak, and the crew had to be told to leave the site by COGCC staff. This was a dangerous situation and clearly was a violation of this rule. While I do believe that staff was generous on the end date, as it was clear by testimony from both Mr. Knopp and Mr. Silva that repressurization occurred as late as October 1st, I will agree with the penalty dates, classification, and penalty amounts as requested by staff. For Rule 1103A, this rule requires that 1, operators must annually conduct one of the maintenance operations on all isolation valves, including A, performing a function test, or B, maintaining the valves in accordance with manufacturer's specification. In addition, Section 2 requires that operators must repair or replace isolation valves that are not fully operable. In this instance, there was a failure of an isolation valve or isolation gate valve, not only once, but multiple times, as KPK staff member Mr. Knopp clearly indicated in his testimony and was documented in staff reports. Once on or prior to September 23rd, and once on or prior to October 1st. This is in spite of the testimony from KPK staff that appropriate actions were taken to repair the valves and resolve the situation. KPK staff in testimony also indicated that they were not aware of maintenance plans associated with these valves, did not have documentation on any testing or testing requirements, and had a hard time recollecting when and if certain maintenance or testing had occurred, and when it could have occurred outside of standard annual flow line testing. And while there was supplied specs on the valves in an exhibit, the testimony provided by KPK staff did not indicate this information was utilized and logs were not kept, so I did not find it credible enough to make it a factual finding. KPK did not replace the failed valves, nor did they make the suggested adjustments to recondition the gate valve. Should it have instances of leaks, as can be found in the manufacturer's suggested maintenance on this type of valve? The overall lack of recollection and confusion amongst KPK staff and testimony as to what, when, and if any maintenance or repairs had or should have been taken was also a serious cause for concern and clearly indicates a need for well-documented maintenance and repair logs of actions by this company, which it does not keep and has not provided. It is my opinion that this was clearly a violation of Rule 1003A. And while I will agree with staff's penalty dates, classification, and penalty amount recommendations that it has provided, I do believe that the end date of the violation could well have been beyond staff recommendation of September 25th, and find the recommendation to be generous. I also believe that the aforementioned information indicates a violation of Rule 605D, that all valves, pipes, and fittings must be securely fastened, inspected at regular intervals, and maintained in good mechanical condition, but agree with staff that this is a substantially similar rule to 1303A, and these violations should be consolidated. For Rule 907A, Rule 907A states operators shall ensure that EMP waste is properly stored, handled, transported, treated, recycled, or disposed to prevent threatened or actual significant adverse environmental impacts to air, water, soil, or biological resources. In this situation, KPK knowingly stored impacted soil from an excavation to expose a leak in a flow line. KPK failed to utilize well-known industry standards to prevent potential impacts, which include utilization of wattles or berms made with unimpacted soil continuously around the whole impacted area to prevent migration, impermeable liners to prevent leaching, and appropriate and continuous fencing around the site to ensure no unauthorized personnel could access the site. In addition, the lack of preventative measures to ensure that no impacted soil could migrate from the site on tires of excavation or haul equipment was lacking. This was documented in exhibits and testimony from COGCC staff and confirmed by testimony by KPK staff during the hearing process. I believe that this lack of continuous berms and lack of utilization of an impermeable base layer or lining below the stockpiled waste, in addition to the amount of time the waste stayed on site, clearly at a minimum threatened significant adverse environmental impacts and is a violation of COGCC Rule 907A. I will agree with staff's penalty dates, classification, and penalty amounts recommendation, though I do believe that the start date for penalty calculations provided by staff is generous, as this was potentially occurring as early as September 19th. For Rule 906A, Rule 906A indicates that operators shall immediately upon discovery control and contain all spills and releases of E&P waste, gas, or produced fluids to protect the environment, public health, safety, and welfare, and wildlife resources. In examining the evidence in relation to this rule violation, I did not find significant, unique, and distinct evidence beyond what was provided in the evidence to support the violation of Rule 1002I2. And while I do believe that the evidence shows that there is a violation of Rule 906A, I find this rule and Rule 1102I2 to be substantially similar in application, and believe that the violation of Rule 906A should be consolidated into the violation of Rule 1102I2. Finally, for Rule 324 Big A Little A, Rule 324 Big A Little A indicates that an operator shall take precautions to prevent significant adverse environmental impacts to air, water, soil, or biological resources to the extent necessary to protect public health, safety, and welfare, including the environment and wildlife resources. Taking into consideration cost effectiveness and technical feasibility to prevent the unauthorized discharge or disposal of oil, gas, E&P waste, chemical substances, trash, discarded equipment, or other oil field waste. This is a broad rule I believe is designed to ensure the protection of public health, safety, and the environment in areas where another more specific rule does not apply to a potential violation. I believe that many of the rules cited in this NOAV are very applicable to the actions and violations that occurred in this situation, and in doing so, and by way of not finding unique and distinct evidence in application of this rule that is different from the other evidence provided in application of other rules cited, I find the application of this rule to this situation to be duplicative. I also believe that the evidence cited clearly indicates a violation of this rule. So rather than deny this claim, I would suggest that this rule violation gets consolidated into the other violations listed, which in turn would support the staff's recommendations on stated impact classifications. So that's my overview.
Thank you, Commissioner Messner. Can you elaborate on that very last point about consolidating the 324A into the others, and like what you mean, that, like what happens with that?
I mean, I think certainly we could, I think 324 Big A Little A speaks to impacts, right? It speaks to a big, broad impact of the situation that occurred in this particular NOAV. I think that uniquely, it could be applied to the specific impact, but another way of approaching that would be to consolidate it into another violations to help bolster staff's impact classification of major.
Can I ask a question of our AAG? Commissioner, or AAG Davenport, what's the legal effect of consolidating one rule into another? Is it still considered a violation, but just with no applicable penalty? Or is in this instance, the 324, does it just go away and we treat the offense under the other rule? I guess I'm a little confused about what the legal impact of that is. Sorry if I don't know the answer to that.
Thank you, Mr. Chair.
I'm not allowed to apologize.
I think it's a good question. I think in my memory of being a prosecutor, consolidation at the staff level would mean that violation was not alleged as a violation. Here, I think what Commissioner Messner has done is find that there was a violation, but that it would be duplicative to assess a penalty, and I'm somewhat extrapolating. And I think that's what I've done in the sheet here, is essentially leave the violation as a found violation, but then delete the penalty. I think that's legally appropriate to do in this case.
So it's a found violation. There's just no additional penalty associated with it.
Yes.
And I guess I turn to my fellow commissioners. Is that what you're thinking when we do that sort of thing, that's what we're doing? I think it's good for the record to reflect this, especially if we're looking at pattern of violations down the road. Commissioner McGowan?
Thank you, Mr. Chair. So those violations are still on record, but there's no actual monetary penalty, and the consolidation then doesn't result in another penalty increasing? Is that what we're saying?
AAG Davenport?
Thank you, Chair. That's what I've done. I would, of course, turn to Commissioner Messner to see if that was his intent in consolidation.
Thank you.
Commissioner
I did not change the classification of anything that was recommended by staff.
Commissioner McGowan?
Thank you, Mr. Chair. So I have a similar issue with the soil spread. So first of all, thank you for putting this all together and all these thoughts, because this was a very complicated one for me, and it was the first one that was presented. And so kudos to you, because there's a lot here. For the soil spread, there's a similar issue, I think, as to whether or not 324A is duplicative with some of the other violations. And I actually looked at it a different way and feel the same way about this one. For me, 324A is for every operator, for everything that you do related to our rules, the very first thing you need to think about is taking reasonable precautions to prevent the actual adverse impacts or the threat of. Like these are the rules of engagement right off the bat for everybody. It's the lowest bar. And so for me, I saw it as a separate violation, and I think for this one too, I would see it as a separate violation, that this is, instead of, if nothing else applies, this one would apply. For me, this one should almost apply for everybody all the time, because it's the rule that everyone should be thinking about first and foremost when they start engaging with us and think about how they're going to meet the obligations and requirements of all of our rules. So for me, I thought it about a different way, and probably could be thought about both ways. So I thought I'd throw that argument out there too for folks to consider.
Other commissioners with thoughts or clarifying comments, I think, is the first thing we do. Commissioner Nanjapa?
Thank you, Mr. Chair. And yes, I just wanted to echo what Commissioner McGowan was just saying. Commissioner Messner, I really appreciate your tackling this one and putting it all together. It was very, very complex, a lot of different pieces there, but I also agree that there was some duplicative, nature to some of these violations. On the other hand, I do agree with what Commissioner McGowan was just saying, that this is kind of one of the basic aspects of, this is 324A, large A, small a, from our prior set of rules with respect to preventing pollution. I guess, are you didn't specify, I know Chair Robbins also asked which rules you would suggest to consolidate this one with. In my mind, it's reasonably similar to either 906A or 907A, depending on kind of how you look at it. I think it's, in both instances, it kind of has to do with, with containment of you know, the leak, the wastes, et cetera. Yeah, so I guess, do you have further thoughts on how to consolidate if you would?
Commissioner Messner?
Thank you, Mr. Chair. So you asked for my thoughts, so here they are. This is gonna get complicated, but so I do think that there are some classifications that are existing in this particular NOAV that are class 2 majors that applying reasonably the matrix could be considered class 2 moderates. And I think that my rationale for consolidating 324 big A little a into these other ones was to bolster staff's recommendation of a class 2 major in those particular instances, because 324 big A little a speaks to impacts, whereas these other ones speak more to more specific mechanics to ultimately what does create an impact, but is a little more of a mechanical type rule. And so that was my thought process for this. I think that you could argue that you should keep 324 big A little a as staff recommended to speak to impacts, but at that point I probably would recommend 3 of these class 2 majors be downgraded to class 2 moderates. And so that was my check and balance on those 2 things. And I think the net impact from a penalty calculation is almost like even. So
Follow-up, Commissioner Nanjapa?
Well, not specifically for Commissioner Messer, but thank you. I really appreciate that explanation. I think that is helpful. I'm still kind of thinking through this. I guess for me, the violations described in 1102.1.1 and 1.2, or wait, am I reading that correctly?
I2 and J1.
And J1, yeah, sorry, I2 and J1. They are, I think those are distinct and separate. I do think there's some potential for duplication or similarity with 324 big A little a and 906 and 907, as I mentioned before. But I also note that those are fewer days of violation. And so I think, I guess maybe this is a bit of a clarifying question for Commissioner Messner. Would you suggest consolidating all 3 of those and then creating a class 3 major, or was it a class 2 major that you were suggesting with in particular, maybe the 907 timeframe, or what are you thinking?
I'm not suggesting any of that. What I'm suggesting is that, and I think Kyle, from a structure standpoint, probably did it appropriately, which is because I believe 324 big A little a is potentially duplicative, but at the same time does bolster some of the classification that staff has done on some of these other violations, that it should be left as a violation, but with not an associated penalty, so that it is clear that the impact was there and that the violation was there of this particular rule, but that the penalty is potentially duplicative. And so I think Kyle has done a good job of taking my thoughts and putting it into a structure.
Okay, thank you, Commissioner Messner. And yeah, and I'm sorry, I also see we've got the note there that 906A would be consolidated with 1102 I2. Yeah, I guess to me then the other violation to consolidate that makes most sense to consolidate with would be the 907A. And then I believe, Commissioner Messer, you did propose a reclass, if I recall correctly, of something, but I maybe missed which one that was or how that would work.
Thanks, Commissioner Nanjaba. I did not suggest a reclassification, no. My suggestion is that, and I probably now I'm confusing things, so I probably should just drop this, but that if it was the commission's thought that they wanted to have the full violation, including penalties associated with 324 big A, little a, then I would recommend reclassification of a couple of these other violations, particularly Rule 1102J1 and 1103A. But I'm not suggesting that. So I don't think we should confuse ourselves with that. So right now, what I'm suggesting is what Kyle's got up there.
I guess I sort of think about it that we do need to be aware of looking at each violation in its singular merits and whether the class and the major, moderate, minor, all of that is appropriate based upon the facts of that violation. I don't have a problem consolidating these two, but at least in my mind, it's because they're similar. I think there still needs to be a finding of violation, but not necessarily additional penalties. But I, at least as one, am not needing that to sort of justify where the others have landed in terms of class and impact. I think that on their own, staff has met the burden on that. And I want to thank you, Commissioner Messner, for taking a very convoluted set of facts and doing a very good job of articulating a position that I am very comfortable in supporting. Commissioner Gonzalez?
We're deliberating or still clarifying questions?
I think I swooped into deliberation by accident.
Yeah, I think a couple of us did too. I don't have any clarifying questions, so I wasn't sure if it was a time to dig in and compare notes, or what the next steps were. So jumping in to see if it's where we're going.
You know where I stand, but do folks want to take some time to go through notes? You comfortable moving into a deliberative aspect at this point? Whatever works for the rest of us.
I am comfortable sharing my notes at this point. So, I mean, if everyone's in agreement, I can just go ahead and get started on that.
Go ahead. Thanks, Commissioner Gonzalez.
Sure. So I'm going to take these kind of out of order. And I'm going to take the low-hanging fruit first. So with regard to 1102J1, I agree. I think there's a violation there. I think the penalty, the classification, and the impact are appropriate. And I think that really, what came down to it was, I think there was opportunities to double check and make sure that pressurization had held in that line. And it's that repressurization that caused that unsafe condition there. And I think that there were some missed opportunities in order to ensure that safe conduct. And because of that, because of the actual impact to the safety of the operation, I agree it's a major impact for that one. I'm going to skip down to 324AA. Again, agree with the violation, classification, impact, and penalty for that one. 906A, same, agree with the violation, classification, impact, and penalty for that. 907A, again, agree with the violation, classification, impact, and penalty for those. I would support a consolidation of 324 big A, little a with the rest of them. I do agree that's kind of a broad overarching rule, and we have specific rules and specific actions and violations that kind of amalgamate to that same effect of 324 big A, little a. So I do find in violation of that rule, but I would support a consolidation of that penalty with the other penalties as well. So that leaves two more that I landed a little bit differently, and I kind of want to talk through those just for a bit. So 1102I2, and I was thinking about this over the weekend. I was putting my notes together, And I came to a position of no violation because I believe that the operator discovered the condition that could affect the safe and proper operation of the flow line and corrected that condition as soon as possible. Now, I was thinking about that and listening to Commissioner Messner's rationale for his finding a violation, and I was, I think, convinced by the strict language of the rule. And I think, as you guys may have figured out by now, I take the rule language and the application of that language very seriously. And so when I think about that, I was thinking, here's the facts that I remember, that basically there's a discovery of a leak. Next day or the same day, the well was shut in, the vac truck came out, depressurized it. And that was the same day as the report from the service owner. So quick action, immediate action to correct it. Problem is, it did not get corrected. And I think that that's what the pivotal point is for me, that it's kind of changing me to think that that was a violation of that rule. Again, with the subsequent leak, well was shut in, temporary isolation valves were installed under the assumption that the isolation valves were the issue. The vac truck depressurized all same day as a staff inspection. So I think that the operator was going out, was addressing these things immediately, but I think that there were subsequent actions that could have been taken to ensure that these corrected the unsafe condition, and they didn't. I think by virtue of the fact that that unsafe condition persisted despite their immediate actions, is where I agree with Commissioner Messner that there is a violation of Rule 1102 I2, and that's a little bit of change on what my thinking was over the weekend coming into this. Skipping down to 1103 A1. So this is one where the operator must conduct a maintenance operation of the isolation valves via a function test or maintenance of isolation valve in accordance with manufacturer specifications. And from my understanding of the testimony, I think they did that. Now, I don't. There's no evidence of function tests, but there's an or in that rule, and it's the maintenance within the specifications, the manufacturer specifications for the isolation valve. As far as I understood, that isolation valve was operating the way it should. It just wasn't making the contact because of an external condition, right? And so when I'm reading that rule and I think they must conduct the maintenance operations or maintain it within manufacturer specifications, I think they did that. And because of that, I found no violation of that rule. I think that's a little tricky, right? So I'm not, that's where I'm landing right now. And so I think that's where I'm going to land. But I think that there is a very valid argument that perhaps the isolation valve, although operating correctly, the function of it or the effect of it was not verified, because there should have been some maintenance or some at least anticipation that debris could foul up the isolation valve, given that that was kind of the first idea that the operator thought of when the repressurization occurred a couple days after the initial blowdown and depressurization of that line. So that repressurization, I think, looking into it, I think there should have been something that was done, and perhaps this is a lesson learned for future evaluation and future operation of these isolation valves. But as it kind of came down to the language of the rule, I did not find a violation for that, because I did find that the operator maintained it according to specifications, given the testimony that I noted and that I recall from the proceedings. So I don't know if AAG Davenport's kept up with all that, but I think that hits on all the points. I will address the last point that I have about the consolidation of 1102 I2 and 906A. I think that the effect of those is, potentially appropriate for consolidation, and I could support consolidation of those two rules. When I read that, though, making an independent decision on my own, if I was offering that up, and I am, I think they are distinct violations. They're the same, kind of the same fact scenarios that occurred, but they were different things occurring within those fact scenarios. So 906A was about controlling and containing the spill and release, and 1102I was operating in a condition that was safe. And so I think the operations and the containment of the spill and release, the operation is the specific activity, and the containment of the spill and release is kind of an omission of activity. And that's why I think those two are distinct rule violations. And from the effect of the penalty or the effect of what it is, I could support a consolidation, but I do not believe that just looking at the way those two rules are written, I do think they contemplate different outcomes and different effects and different protections and different actions along the way. So I'm not quite sure how to land on that. And perhaps AAG Davenport, maybe I can ask you a question about, yes, similar timeline, similar facts, but within that timeline and facts, they're really going to different actions or lack of action from the operator. And does that still justify a consolidation kind of in that view?
AAG Davenport.
Thank you, Chair. Commissioner Gonzalez, I agree with your analysis. I think when you're looking at consolidating violations, it's the language, as I recall, in the enforcement guidance policy is substantially equivalent or something along those lines. I think that's a totality of everything in regard to that. What is the activity that the rule is directed at? What were the facts that supported the allegation of a violation? I think if everything is the same, in other words, it's directed at the same activity, it's the same facts supporting the violation, then consolidation is something that should be discussed. You've noted that your view that the rules are really directed at different activities, and it's a different activity that could result in a violation. And I think that analysis makes sense to me. Thank you. The chair's just reminding me as to the language in the enforcement guidance. Is the violation based on the same operative facts, and are multiple rules focused on preventing the same harm or the same actions of the operator? Thank you. And if I may, given that we have so many violations, I've not previously been writing down when other commissioners have suggested changes as well. I'm going to do that now just to keep track of it and so you can all see it. So Commissioner Gonzalez, I believe that you indicated your view that we should have a finding of no violation for 1103A. Okay.
That is correct.
Okay.
And I'll kind of finish my my statement there. I think that given my understanding of the consolidation of the duplication kind of policies and your I guess confirmation of that, I don't believe that a consolidation of 906A and 1102I2 is appropriate. And so that's kind of the final piece that I'm landing on there.
Commissioner Messner.
Thank you, Mr. Chair. And thanks for that analysis, Commissioner Gonzalez. I think that was good, and actually brought a different perspective to me as far as whether or not 906A and 1102I2 should be consolidated. At this point, I'm going to tend to agree with you that they perhaps should not be consolidated. I looked at them more on whether or not I would utilize the same evidence to come to the same conclusion, but I think your point that these are really two different items, one is a control and contain, and one was whether or not the condition was safe, is a compelling argument for me. So I would agree with you on that. As to 1103A, I would note that while I had a hard time, I'm having a hard time lending credibility enough to make a factual finding from some of the comments that came from KPK staff around whether or not they actually had and utilized maintenance plans, and the fact that generally speaking, they would not provide them. And I do acknowledge, and I did acknowledge in my statement, that they did provide to COGCC staff the specs on these particular valves. What I find interesting, though, is that as I read those specs, it specifically talked about leaks in isolation gate valves, which is the one that they had indicated is utilized on this flow line. And within there, it talked about a specific adjustment to recondition that particular gate valve in case there was issues of leaks, and that there was an adjustment within the valve itself in order to address leaks. I heard no testimony or saw no documentation from KPK around any adjustments that they attempted to make on this. Rather, they just indicated that it was, you know, a piece of debris that was causing this. And so I find that odd when there was a very short section in these specs regarding maintenance, and this leak piece was one of the main ones. And that was never mentioned as a preventative course of action from KPK staff in any of their testimony or statements. And so to me, that makes me think that there really was not any maintenance or we're not following the manufacturer's specs on this particular piece of equipment.
Others with comments? Commissioner Nanjapa?
Thank you, Mr. Chair. And yeah, thank you, Commissioner Gonzalez, for your thoughts and for this discussion that has just been occurring here. I think I am also compelled by Commissioner Gonzalez's analysis that the 906A and 1102I2 are separate. I did believe in the first place that 1102I2 and 1102J1 were distinct, but I was kind of considering these a little bit differently as we were going along, but I think I'm back to where I was, and I do believe those are distinct. And I was kind of going back and forth about the 1103A, but I think per Commissioner Messner's comments, I think I am inclined to say that that should remain as a violation.
Commissioner McGowan?
Thank you, Mr. Chair. I think for 1103A, just going back to what I think staff has to show, which is a preponderance of the evidence, I'm not sure that they've been able to do that because I'm not sure they can prove that the operator hasn't been maintaining their equipment. They say that they have, but they just don't document it, which to Commissioner Messner's point is, how do you read that? How do you interpret that? They submitted the maintenance manual for it, but that doesn't mean you use it. But we have to, I think it's, if I'm understanding correctly, the bar for our staff is to show a preponderance of evidence that something has occurred or not occurred. So I think I'm leaning towards Commissioner Gonzalez's point that I'm not sure that we can, that we've jumped over that bar.
I agree on 1103A with Commissioner Gonzalez and at least some of the others. So do we have sort of final thoughts on all of them at this point? Okay, why don't you hit us up with outstanding issues, Mr. Davenport?
Commissioners, in listening to the deliberations and trying to keep track of where everyone is, I believe we have at least 3 commissioners who are in agreement that there was not proven to be a violation of 1103A/605D. I think it sounds like there's general consensus at this point that 906A should not be consolidated with 1102I2. And I have not heard any commissioner specifically come out and oppose, with perhaps the exception of Commissioner McGowan, consolidation of 324A with the other violations. I think those are the issues that have been raised in the course of deliberations. And so where I think we are is we're not consolidating 906A with 1102I2, finding that a violation of 1103A was not proven, and we are still consolidating 324A with other violations. And no other changes to what Commissioner Messner proposed in his initial statement.
I think that's accurate. And so the change to the document we're looking at would be to remove the red line there. Yep. And then reinsert the penalty to the right, 4 boxes over, 5 boxes over.
And then I'll need to go down if we're sticking with finding of no violation for the last one.
Yeah, I think that's accurate as to at least 3 of us. Any final thoughts on this matter? Commissioner McGowan?
I'm fine with this outcome. I just want to be on record saying that I think the 324A is a separate violation, but I'm good. Thanks.
Everybody else okay with where we are? Going once, going twice. All right, we've been going at it for 2 hours and 57 minutes. Why don't we take about a 15-minute break and return at 3 o'clock for final deliberations. And we would go Commissioner McGowan with soil spread fields. I will do Jilson, and then we'll come back to the one that was reserved. Okay, welcome back, everybody. It's 3 o'clock. We'll continue with our deliberations. We have 2 final NOAVs to go over, a recheck with 1 claim and 1 NOAV, and then some sort of closing process. So with that, I think that Commissioner McGowan will walk us through her thoughts on the soils spread field.
Thank you, Mr. Chair. And I think I'm going to do what Commissioner Messner did, which is just kind of go through my whole thought process. And then if folks don't mind, then we can deliberate after that or ask questions or clarify. I think my brain works a little bit differently than everybody else's. So bear with me while I go through the process that I went through to organize myself. So the first thing I felt that it was important to address was the KPK arguments that they did not intentionally or willfully create the E&P site, waste management site. And I guess my first finding is that I don't think that our rules require a showing of intent in order to meet them or not meet them. And so I did not find that a valid argument to not apply any of our rules or find violations. The second argument that was made was that they denied that they were creating a centralized E&P waste management facility at this location. And I believe that since KPK actually runs its own permitted E&P waste management facility per testimony this week, I think that they should have the knowledge and expertise to understand what it means to characterize waste and properly dispose of it and create an E&P waste facility. And so I did not find that a compelling argument either. So to the violations, I did find that there were violations of 324A, 907A, 907E, and 908B. For the first one, which is failing to take reasonable precautions, the 324A, the general one, failing to take reasonable precautions to prevent the contamination of soil and surface water. I felt that by spreading E&P contaminated soil in a large amount, 300 truckloads, over a large area, I think testimony said it's about 90,000 square feet, that KPK did not take precautions to prevent significant adverse environmental impacts to protect soil. They overlaid the native soil, which is Vona loamy, with 1 to 2 feet of soil from the Nesu 1 location, which was higher in levels of clay. And in addition to that, 9 of the 11 samples that were taken by staff were of that clay nature instead of the Vona loamy sand. Staff samples also showed Table 910 exceedances for total petroleum hydrocarbons, sodium absorption rates, and total electrical conductivity. And those are tests that are used to determine if a soil is an EMP waste or not. KPK, some of their samples also showed exceedances, although in smaller numbers. I also think that they did not take precautions such as berms or liners to protect potential groundwater impacts or to the freshwater pond that was 100 yards away or the adjacent wetland located less than 400 feet away. For 907A, failing to properly manage their EMP waste to the extent necessary to ensure compliance with Table 910. Whether KPK knowingly spread contaminated soil, the soil samples taken from the site show certain levels of contaminants were above Table 910.1 protective levels, which therefore characterize the soil as EMP waste, and therefore demonstrate the soil was inappropriately managed and was not exempt from regulation as an EMP waste. The soil was not properly identified or characterized. PID tests and visual and olfactory are inadequate to properly identify and characterize waste, which would have prevented mischaracterization from the beginning, and improperly storing EMP waste put the groundwater, adjoining wetland, and nearby surface water at risk for adverse environmental impacts. For 907E, failing to properly dispose or treat of oily waste from a spill point, both KPK and COGCC lab tests show levels of hydrocarbons that violate 910 standards, thus providing evidence that the soil spread at the site was oily waste. I believe Mr. Gatatis testified that the TE-PhD levels in some of the samples were 3 to 4 times over the 500 milligram per kilogram limit for oily waste. In addition, at the June 30th, 2020 inspection, staff observed hydrocarbon staining on the soil that KPK had placed in the soil spread field location. And during testimony, Mr. Knopp testified that he also observed stained soil at that same inspection. If both gentlemen could observe visually the existence of the stained soil, it seems logical that others working at the site observed the same, but did not pause to request any additional testing beyond what was done at the Nesu 1 site. Therefore, I agree with Commission staff that KPK failed to properly dispose of or treat oily waste and dispose of it at an unpermitted facility. For 908, I think it's 908B, failing to submit a Form 28, I agreed. They spread soil at they spread contaminated soil and EMP waste that were in violation of 910 concentrations, bringing in truckloads of soil to a centralized location and spreading it out in a defined 2-acre area constitutes construction. Soil sampling and testing show that the soil was waste, and so therefore they were running an EMP waste management facility without the proper Form 28. Sorry, now I gotta go back to my other form. I did think that I didn't agree with all of the impact as major, and I did not agree with the end date from staff. The end date from staff was after the soil had been removed, and I thought went a little beyond the rule, which is when remediation is commenced. At least I think that's how we're supposed to read it. So what I thought was a more appropriate end date for all these violations, or sorry, the first 3, was February 8th, which is when KPK notified COGCC via manifests that corrective actions had commenced. That's when the soil had been removed. It's unclear to me if KPK notified staff before then that they had started removing soil. So I picked the date at which they notified us that the soil had actually been removed, and they were shared a manifest on February 8th of that. So for 328, 907A, and 907E, I did feel that the impacts were moderate instead of major. I think that it's difficult to prove that there was an actual impact versus a threat of an impact from the soil and any sort of runoff that could have occurred. There were groundwater and soil samples taken that did not show any violations of our standards. And so I thought that those were more appropriately moderate instead of major, which changes the daily penalty amounts.
Commissioner McGowan,
Yes.
I apologize for interrupting. Which rules?
324A,
Okay.
907A, and 907E.
Thank you.
And so the number of days of violation changed from 433 to 291, if I'm doing my math correctly. And the daily penalty for 324A goes from 15,000 to 10,000. For 907A, I think it goes from 10 to 5. For 907E, it goes from 10 to 5. I did feel that these were all separate and distinct violations. Failure to take precaution to prevent a contamination in the first place would be 324A. Failure to properly characterize the waste would be 907. Failure to get a permit and appropriately dispose of that waste is 907E, and then failure to actually fill out the form and get the permit would be the 908B. So I felt that these were all separate violations. KPK also asked for consideration for mitigating and aggravating factors, and that they thought remediation costs should be considered as a penalty adjustment factor when the cost of the environmental remediation exceeds any economic benefit for non-compliance, and the total proposed penalty for the violation outweighs economic benefit. However, I think that another mitigating fact that we're supposed to consider is we're supposed to exclude circumstances in which the increased costs stem from non-compliance. This is not at the original site where the historic soil was found. They actually created this site themselves. They created the non-compliance here. And therefore, I think that it should be excluded as a mitigating factor because the increased costs stem from their own non-compliance and the creation of their own non-compliant site. I think I am done.
AEG Davenport, are those firm numbers that you're typing up there? I mean, that's got the duration matrix and et cetera.
Yes.
Sorry, I also changed 908 from major to moderate, which takes it from $10,000 a day to 5,000.
Thank you, Commissioner McGowan. Would you double check what I have up on the screen and make sure it's captured everything?
Yes.
And to answer your question, thank you, Commissioner McGowan. To answer your question, Chair, yes, those penalty amounts include application of the duration matrix.
Thank you, AG Davenport. Appreciate your and Ms. Larson's nimbleness here with us on this. Clarifying questions from commissioners to Commissioner McGowan. Commissioner Messner?
Thank you, Mr. Chair. And thank you, Commissioner McGowan. That was a really thorough analysis of a difficult NOAV. I think my one point of clarification is that they need to commence remediation, but to the director's satisfaction. So it clearly states, and there was testimony and discussion during this hearing about that term, director's satisfaction. And so I guess I'm I'm curious how you weighed that director satisfaction piece, because that did play a lot into my consideration and determination of what the end date should be.
I considered that as well. I just thought that it the main damaging activity, if you will, was all the soil on site, and all the soil had been removed by February. And I realized that staff has said that they were still taking samples, but some preliminary samples had already been taken and come back within the compliance standard. And while I want to give deference to staff, it did seem a little overkill to me to go all the way out to the further date, where staff felt that the date that they chose for compliance that included some further groundwater testing, in my mind. So.
Other questions, clarifications from commissioners? Well, you did an excellent job, because there's no clarification questions or things. So I think you're winning on that front. Congratulations for doing a great job. Really appreciate it. That was a lot of convoluted facts and information. Do commissioners, are we in a spot where we can move toward whether the four of us are ready to deliberate or provide our perspective on where we may be with regard to this matter? Race to the unmute button. Commissioner Nanjapa.
Thank you, Mr. Chair, and thank you, Commissioner McGowan. I agree. This was, there were a lot of different pieces to this one as well that were challenging to kind of work through. But I thought your analysis was really great. I think I'm a little bit mixed on the Rule 908 with the creation of a EMP waste management facility. I think, we heard, while I agree the construction, began when they disturbed the soil, or those kinds of things, or that type of activity would normally be the case. I do believe that they were under the impression that what they were moving was not E&P waste. And while I think, 907A still applies, because, it ultimately did turn out to be that way. They didn't conduct appropriate testing to confirm it. I was a little bit torn on whether this was truly the creation of a waste management facility and whether that Form 28 would apply. I think I could kind of I can see it from the staff's perspective, and I can see it from KPK's perspective. That said, I do believe the other violations have occurred, but I also agree with your reclassification. I'm still noodling a bit on the start and end dates, but I think for me, I don't have any question about the violations in the first three here, 324AA, 907A, and 907E. So I'll just start there.
Commissioner Gonzalez.
Thank you, Chair, and thank you, Commissioner McGowan. Very thorough, very thoughtful. In I would say, kind of to summarize it, I'm in agreement with all your suggested changes, and I landed on the same spot for all four of these violations. I want to add a couple pieces of context, right? So the operator had suggested that we have an end date of the commencement of their corrective actions, which they state was August 10th, 2020. And that's when they started stockpiling and preparing the soil for removal. Well, when I was thinking about that and considering that argument, I was thinking that's almost 11 months before that site was actually fully cleaned up. And I think that in that context, I had a really hard time thinking that the corrective actions actually commenced as early as August 10th. I was struggling to what that end date was because I was thinking 6/30/2021 was probably a little too far out in that regard. So in that regard, I think, you know, when they got to the spot where they had removed the soil and then were remediating the existing underlying conditions of the field as of February 8th, 2021, I think that's an appropriate spot to land for the end date. And so I appreciate that suggestion, and I support it. Let's see. And then for the last one, for Rule 908, you know, I had a hard time with this one, and I asked staff some pointed questions in our when we had them up and when they were presenting their case in this regard. And, you know, what came down to for me is that if you're deliberately placing waste, EMP waste or impacted soil at a location for the permanent storage of it, and you're going through the efforts to spread it out and to, you know, essentially integrate it into that field, you are essentially creating a facility, and a facility has been created, right? And by spraying it across the field, you are managing that EMP waste. And so that's kind of where I landed on that last point for Rule 908, was even if you didn't intend to create something, that it's possible to create it. And I think that's what happened here. You know, it's a one-day violation for the permit. I think that's appropriate. I think the impact level is appropriate, and I would agree to find a violation of Rule 908. So agree across the board, in short.
Thank you, Commissioner Gonzalez. Commissioner Messner.
Yeah, I don't really think I have much to add. I think I agree with both Commissioner Gonzalez and Commissioner McGowan for the reasons stated. So I'll keep it short.
Thank you, Commissioner Messner. I think I'm of the same opinion. Just a couple of additional editorial points. You know, not only did they need to get a permit to do what they did, but they were under the forms, it said everything needs to go to the landfill. And yet again, this is just a tremendous example of a failure to dialogue, a failure to reach out to COGC staff, a failure to get a determination of whether this was even appropriate. And frankly, I was a little disappointed with the concept that they wanted to get extra bonus because they had to remediate. Well, frankly, if it wouldn't have been for an anonymous tip, we never may have found out about this. And then they would have scored big savings by using their own land for a bunch of EMP waste. So I'm not inclined to move away from, other than the, I think, thoughtful approach that you've taken here, Commissioner McGowan, with regard to the edits that you've made. And I am in favor of where you've landed. And thank you for doing a great job of a difficult one. Commissioner Najapa?
Thank you, Mr. Chair. I appreciate those remarks. I think in kind of rethinking some of these factual matters and recognizing or reminding myself again that this is a one-day violation, I think I will withdraw what I said before. As I noted, I was struggling with it. I think the question of knowing and willful is not on the table, but that's a separate matter that we'll take up later. But I think it's I see, you know, per the comments that you all have made, that there still was a violation here, and this was an inappropriate way to handle this material without knowing with certainty that it was not E&P waste.
AEG Davenport, do you, are we with consensus at this point here?
Thank you, Chair. I think we are. Commissioners, the table you see before you is my edits with Commissioner McGowan's guidance. I don't believe any commissioner wanted to make ultimately changes to her suggestions. And so Mr. Chair, it appears to me that we can move on.
Great. Once again, great work, Commissioner McGowan. You made edits that have withstood any additional changes from the rest of us. That's awesome. Okay. I had the final NOAV, the Gilson number 5 flow line. I've got a little script that I'll just read through both the proposed violations and then we can talk about it. This involved Rule 906B, KPK, and so I'm going to do that one first. The commission, to find a violation of 906B, the commission must determine that an operator failed to report to the director in the applicable time period after discovering a spill or release of E&P waste, gas, or produced fluids that meet any of the following criteria, and it's criteria A spill release of any size that impacts or threatens to impact any waters of the state, a residential occupied structure, livestock, or a public byway. So my review of the evidence and findings establishes the following. On July 15th of 2020, KPK was informed by the landowner, these are 3 family members of the Thomas family, of a gas release on their property from a flow line. I find the release to be reportable because based upon implied facts, it was a size and quantity that the landowner was aware of. In other words, if they were not aware of it, they had to become aware of it because they knew of it. And so, again, we don't know exactly what happened because they were not called as witnesses, but I believe it was gassed. I believe that gas could combust. It was in a field which was next to a public road, which was approximately 3 strides of a 6'2" Chris Canfield. So I'd say about 10 feet or so. I also find that it was within close proximity to a ditch, which is waters of the state. I find staff met its burden of proof that it was more likely than not that the gas release was a threat to impact a public byway and waters of the state. I do not find that staff met the burden as to a horse or close to livestock for reasons I will note below. I am also influenced in this finding because I feel KPK should have done the right thing and called their COGCC contacts to alert them as to the spill released, to dialogue with them as to whether a report was indicated. I'm very concerned, and I've mentioned this several times today, that KPK appears to make the call whether something is reportable or not on their own without dialoguing with COGC staff. Our enforcement protocol is forms-based, and as we heard from multiple environmental specialists, they do not have the capacity to be everywhere and observe everything that occurs at all oil and gas locations. The form-based dialogue between our operators and COGC staff is completely necessary to ensure, 1, compliance with our rules, and 2, when an oil and gas facility is out of compliance, that it is returned to compliance as soon as possible. Those are the goals of our enforcement statute. Making the judgment call alone by Mr. Knopp without picking up the phone where there is an apparent and ready access to COGC staff is not what I believe the rules contemplate, and I'm not really keen on rewarding an operator who fails to make a determination with staff as to the question of reportability of a potential spill or release. As to the penalty calculation, the rule class identified by our guidelines and supported by testimony of Jeremy Farron is Class 2. I don't think this was just a paperwork or ministerial violation as advocated by KPK. While it involved filing a report, the failure to file a report brought potential threat, public health, safety, welfare of the environment, the road, and waters of the state. This failure to file the report provided a hidden problem, hidden to staff that is, which staff was then unable to address via our rules to ensure timely closure. In fact, had KPK not been delinquent in resolving the problem, staff may have never known about the concerns because the complaint may have never been lodged. Also, I find that the actions or inactions by KPK in leaving the open hole for several months was additional threat to public health, safety, welfare, the environment, and wildlife resources. I propose leaving it as a class 2 and leaving it as staff has indicated as a minor impact level with a correlating daily penalty of $2,500. I believe the start date, July 7/16/2020, is uncontroverted, as that is the day following KPK being alerted to the gas bill released by the landowner. I believe the end date to be uncontroverted as well, as being 10/22/2020, which is the day KPK filed its form. I note with regard to consolidation that staff has already consolidated the 4 906B violations into a single violation, starting on July 16th and running through November and running through the end date, which I think is fair, appropriate, and reasonable. I also note that that the duration matrix, which reduces penalties for violations longer than 10 days, which I also find to be fair, appropriate, and reasonable. And I think I have my notes wrong. It's not 10/22 is the end date. It's 11/6, which was the end date. So I find the 113 days of penalties of $2,500 a day mitigated downward by the duration matrix for a fine of $46,300 to be appropriate, fair, and reasonable. Finally, I note, and I know you guys didn't do this, but I had in my notes, for the record, that we are not taking into account ability to pay, nor are we considering aggravating or mitigating circumstances, which will all be considered at a later hearing date following the pattern of violations hearing. So in sum, the staff claims table remains as is, and I do not take up pattern of violations. With regard to the second alleged violation, to find a violation of Rule 906C2, the Commission must determine that an operator failed to make good faith efforts to notify and consult with the affected surface owner prior to commencing operations to remediate E&P waste from a spill release in an area not otherwise being used for oil and gas operations. I reviewed all the email exhibits, which I considered the best evidence of the dialogue between KPK and the landowner. I also considered the evidence of discussions that Chris Canfield had with the landowner after the fact, noting that that's hearsay, and the evidence of discussions that Avi Mailer testified to in his discussions with the landowners, noting that also is hearsay. Having reviewed all that, I do not find evidence sufficient to support a conclusion that the operator failed to make good faith efforts to notify and consult with the affected surface owner prior to commencing operations to remediate the problem. Instead, I find the evidence establishes a frustrated group of landowners with KPK's inability to get out there and get the work done in a timely manner, something which, while bothersome, is not a rule violation. As support for this conclusion, I note there are repeated references from the landowner in the emails, such as wishing you and your family a healthy and safe Thanksgiving on November 23rd. Hope you and your family have a nice holiday and a happy new year on December 22nd. Had the property owner been frustrated with the amount of communication as opposed to the timing of getting the work done, I think the response, as opposed to the responsiveness to fix the problem, I think the emails would have noted that there would not have been such niceties. I also note there was good faith communication with the landowner concerning the type of reclamation seed mix. I also note the longest lack of communication was between August 10th and October 2nd. However, that's the lack of email communication, and I do note that not all communication was by email, because on October 2nd, and I note that's a Friday, Mr. Mueller talked to Brandy Thomas. Sorry it took me a few days to respond to your phone call earlier this week. Going to have a crew out there the following week. And I note that's October 5th to October 9th. And it looks like when they failed to act that following week, i.e. by October 9th, on the following Wednesday, October 14th, the landowner emailed to Mr. Mailer, Avi, I wanted to make you aware that because the site is not fully cleaned up, we submitted a complaint with the COGCC today. We hope this will spur some action. So even with 7 weeks of no emails, I don't find there was a lack of communication, but I find a tremendous lack of activity. And when that lack of activity resulted in yet another failure to get out there and clean up the work, the landowner was forced to file the complaint. I also do not see anything, back to the horse. I also do not see anything in the emails where the landowner is complaining of being unable to use the field to house his horse or livestock. I also note that Mr. Knopp also testified the field fencing was not contained. I think had the landowner been frustrated about field usage, that would likely have shown up in the emails as well. So all in, I find staff did not prove by a preponderance of the evidence that there was a failure to make good faith efforts to notify and consult with the affected surface owner prior to commencing operations to remediate E&P waste from a spill release in an area not being utilized for oil and gas operations. And as a result, I propose that the 906C2 violation be dismissed. In closing, I also would like just to note that it would have been really nice to have heard from the landowners in order to present a case along these lines. But we're not in charge of calling witnesses, and they were, not called. But those are my thoughts, findings, conclusions, inclinations on these two matters. I now turn to my fellow commissioners if you would like any clarifying questions. Commissioner McGowan.
Thank you, Mr. Chair. Thanks for succinctly putting this all together. I'm wondering how I'm reading the rule. The operator shall make good faith efforts to notify and consult. Did you feel that when you were looking at, one, I'd like to say emails, just because people are nice, sometimes are indicative of, have you ever worked with a contractor? You're like, don't make the contractor angry. And you're like, how are you today? Even though inside you're like, when are you going to finish my bathroom? You're nice because the person kind of has some power and control over what happens or doesn't happen in your life. So I just want to put that out there. But notify and consult, what do we mean by that versus just sending an email and saying, I think I'm going to be out next week, and then you're not out next week, and then you don't get an email until the communication is back from the landowner saying, you said you're going to be out next week, but you didn't come out. Is there really consultation going on there? I'm wondering what you thought when you were going through the emails, what you thought about that.
Yeah, I came down with the fact that we just really had a dearth of evidence to support this claim. I think if we're trying to provide to the commission evidence around whether there was notification and consulting, again, I really would have liked to have heard from the aggrieved party. I just, at the end of the day, by a preponderance of evidence, could not make the finding that there was enough evidence in the record to establish that they were indeed aggrieved by not fully being notified and consulted. I also noted at the end of the day that ultimately what they were most concerned about, the seed mix and how that was done, that their landscaper was able to talk with the operator about that. And I didn't see anything in the record that established that that issue, which was one of the pertinent issues, did not seem to be addressed appropriately. So, I mean, that's sort of my call on whether there was sufficient evidence in the record to satisfy the burden of proof. And ultimately, at the end of the day, despite the fact that they were, fairly decent emails, and I also note that, the other information was indeed hearsay. And so I put some weight toward that. And at the end of the day, when staff has the burden of proof, when the best evidence I've got that's not hearsay are emails, I tend to look to that. Other clarifying questions? Commissioner Messner?
Just a clarifying question. As you were reviewing the emails, did you find that the landowner did know when when KPK was going to commence operations to remediate EMP waste from a spill or release? Because if I'm recollecting in my notes, I think when they finally did, even though it was communicated a number of times over a number of months that they were going to be out there next week, when they finally did get out there, I recollect it being a surprise to the landowner.
I don't know that I had information that I reviewed that established one way or another with the landowner. Again, I think there was a lot of frustration about lack of activity. But at the end of the day, I think that the main concern that I saw from the emails was you need to fill the hole. There's an email from November 23rd from Mr. Thomas to Mr. Maley that the open hole is very large and not far off Gooden Hollow. Do you have an estimate for completion? And then the last email spoke to the land seed mix, and that seems to have made its way over to the operator. And so I think filling the hole and then reseeding was what was important to the landowner, and that seems to have occurred. But it's all, it's not actual evidence and testimony. We're reading between the lines and trying to patch up the case from staff. Commissioner Messner?
Yeah, I appreciate that. I would agree with you on this particular item. That had we heard testimony directly from the landowner, I think we could have gotten a clearer picture as to what kind of communication actually was occurring and whether it was appropriate or not. But because we were trying to read between the lines on emails and some testimony from KPK staff, I think I will agree with you on 906C2. I also think that you made a good rational argument to 906B, and so we'll agree with you on that one as well.
Commissioner Messner, just by way of clarification, I printed off the exhibits for this one, and there's another exhibit on December 22nd email from the landowner, and there's a back and forth about the fence and how the new fence is not sufficient and that they needed to redo it. And then there's an email later that day about the seed mix. So it seems like there was some back and forth about remediation efforts between the company and the landowner in late December when they actually went out there and tried to do the remediation. Commissioner Gonzalez?
Thanks, Mr. Chair. So with 906B, I agree with kind of the final outcome there. I think one of the things that was impactful to me was I thought that staff, given the proximity to the road and the proximity to the ditch, had a pretty low bar to clear to prove up to me beyond a preponderance of the evidence that there was going to be an impact to those. When you are just a couple strides from the, a thoroughfare and 30 feet from an irrigation ditch and there's an active release going on, I think that that's good enough to me to imply that threat to both waters of the state and a public byway. So I'm with you there. With 906C, I struggled with this one a little bit, right? And I've been in Mr. Mailer's position. I've been the one talking to landowners, working with the operations team and trying to get everything coordinated. And sometimes it's really hard to do because you're working with different teams and different schedules and trying to get all that coordinated. So I've got some understanding of how challenging it is to make and keep commitments from an operational perspective despite best efforts in terms of internal scheduling. That being said, should have and could have done better. I think what it comes down to for me is the good faith efforts to notify and consult. And I would think that based on what I saw in the testimony I heard, that there were good faith efforts to notify and consult. And one of the bigger dates that stood out to me is the date that KPK began site excavation, right? So digging up the hole on September 24th. There was a gap in emails between August 12th and September 24th. And to me, that was kind of the impactful biggest gap that I saw that could lead to perhaps a lack of notification, a lack of consultation, or an appropriate notification or consultation. But again, I kind of hampered that against the good faith effort that I did take from the tone of the emails, from the fact that they have Mr. Mailer's cell phone. I believe that there was more communication, just the emails that we saw as part of that exhibit in KPK's filings. So I'm with you that I don't agree this is a violation. Should the majority of us agree that it is a violation, my thoughts for the appropriate end date there, or the appropriate time frame, would have been August 12th, 2020 to 9/24/2020. But that's just kind of where I would have landed had we gone there. And perhaps there are other commissioners thinking that may still be the appropriate landing spot. But where I'm at is I think that there was good faith effort to consult and notify, and that this violation should be dismissed.
I think we've now moved into deliberation, but if you'd like a clarifying question, Commissioner Nanjapa, go for it. Then you're
No, I'm ready
recognized
to
for
deliberate.
deliberation.
Oh, sorry, were you inviting
I
me
was
to
going to say,
start?
whatever you like. Starting
No,
to get late
I
in the
didn't
day.
have a question, so we can proceed. Yeah, thank you.
Anybody else with clarifying question, or do you guys want to move into the deliberation phase? Okay, I'm seeing nodding heads. Who wants to unmute first? Commissioner McGowan?
So I agree on the discussion of the 906. I will note that it probably takes a lot to get somebody, a landowner, to submit a complaint to the COGCC, and that there's a difference between I'm not getting communicated to versus things are not happening as quickly as I think they should, which is another issue, unfortunately, that don't appear to be addressed in our rules. And so I agree with your assessment of the 906C and 906B.
Commissioner Nanjapa?
Yeah, thank you, Mr. Chair, and I appreciate the discussion and your thorough handling of this one. Just to keep it simple, I agree with both of the ways you suggest in handling these violations, including the dismissal of 906C2.
Commissioner Messner, do you want to weigh in?
Thank you, Mr. Chair. I thought I already did.
Okay.
Yeah.
All right, AAG Davenport, are we good on this one?
Mr. Chair, I believe we are. I think the consensus is no changes to the table proposed by staff in the course of the hearing, and to dismiss the alleged violation of 906C2.
Okay, we've made our way through the 5 NOAVs. I believe, AAG Davenport, we had reserved finalization of one element of one NOAV.
That's correct. Nesu Consolidated, which I will bring up in a second as soon as I'm done editing this one. We had not, the commission had not decided as a group in regard to I think it was the second violation alleged. Give me 1 second while I pull that up, please. It's up now.
Okay, we have this issue back up. I think this, to sort of reorient ourselves, this is the waters of the state, the irrigated, non-irrigated field, the issues around that. I believe that myself and Commissioner Gonzalez were of the opinion that a violation was not proved up, and perhaps that Commissioner Najapa and Messner were remaining of the contrary opinion? And not to put you on the spot, Commissioner McGowan, but I think you were the one that was kind of trying to figure out what was the appropriate landing spot for yourself on this one.
Thank you, Mr. Chair. This one's just been very hard for me. I think I'm back to the preponderance of evidence that staff had to show, and I just feel they're this short of that line. And so I'm going to agree with Commissioner Robbins and Gonzalez that there's just not enough evidence for us to know about this one.
Okay, so with that, the claim 2 would be dismissed. We've already established claim 1. So we'll let Kyle make that edit. Okay, with that, I think we now have made our way through the 5 NOAVs that have appeared and been presented to us all of last week, or Monday through Friday of last week. I believe that at this point, this hearing is now concluded for today. I do note that Ms. Larson, when is the remaining 3 NOAVs as part of this docket? What are the dates for those hearings?
They begin this Wednesday, the 18th. Forgive me, let me pull up the calendar so I'm not giving you the incorrect dates. Wednesday, the 18th, and then we'll come back on Friday, the 20th, and then Monday, the 23rd. Yes.
Sorry, I didn't hear if there was a question. What the yes answer was to.
Okay, sorry, I was doing 2 things at once. So the worksheet, excuse me, the worksheets that we have worked up for each NOAV will find their way to the website. I remind the folks that are listening in to what we're doing that there's 76 attendees. These are, and Kyle or Age and Edward, I'll let you clean up anything I'm about to say, but these are not final orders. They are not final agency actions subject to appeal. They are interim orders.
I think that's fair, sure.
Interim non-binding, well, they're binding. We're not going to go back and change them unless when we look at mitigating and aggravating circumstances with regard to pattern of violation, ability to pay. But so next steps are, we'll have the hearing dates for the next 3 hearings, and then we will have the hearings officer entertain the procedural work that needs to be done for the pattern of violation hearing. So parties, you've been informed that you need to take that up with the hearing officer. And then we would have the pattern of violation hearing. And then following that, we would potentially revisit all 8 findings, the 5 that have happened today, as well as the others, and determine whether or not, if we found a pattern of violation, that there's any repercussions to these interim orders. But we're not doing anything at this point on that. Did I get that right?
That's right. Yeah.
Okay. Ms. Larson, you look quizzical.
No, nothing more to say. Thank you.
Okay. I am aware that a motion was filed by KPK relative to the other 3 hearings. Ms. Larson, do you want to brief us as to that motion? I will likely recuse myself from consideration of it, but since it has something to do with time, we might as well knock that out right now.
Certainly. Thank you, Mr. Chair. So this morning we received a motion from KPK's counsel requesting additional time in order to present its final case on the remaining 3 NOAVs. Currently, KPK has an hour and 33 minutes remaining from the 6.5 hours that it was allotted for its case in chief on all 8 NOAVs. KPK requests that it be granted an additional hour and a half so that it be allowed 3 hours to present on the remaining 3 NOAVs. Staff has, if I'm not mistaken, approximately 2.5 hours remaining of time on left to present their case on the 3 NOAVs.
And Ms. Larson, 2 of our attendees have raised their hand, one of whom, Ms. Stafford, as well as Mr. Jacobs, are the attorneys of record. Commissioners, I'm going to recuse myself because there's no reason for me not to. I believe Commissioner Gonzalez has agreed to be chair relevant to the next 3 matters. So Commissioner Gonzalez, I'm going to turn this over to you, and then I will be in another room. If you guys come back and we have additional business before us that has nothing to do with the other 3, then I'll come back in, but I'll wait to hear from Kyle. Is that fair, Commissioner or AAG Davenport?
Yes, Mr. Chair. Commissioners, if I may address a few things. I have a question for you all, and the first one is I don't know if you've seen this motion yet. Ms. Larson, do you know if the commissioners have seen this motion yet?
The motion has not been emailed to the commissioners. It is in the docket, but it has not been emailed to them.
Okay. Commissioners, have you all had an opportunity to actually see this motion? No, it looks like you're all shaking your heads no.
I have not.
Okay. Mr. Chair, I'm happy to hear from you or any other commissioner if you'd like to suggest a path forward. If you don't have a suggestion, I'm happy to help work through a path forward with you.
Well, I am pulling up the motion now.
Mr. Chair,
Yes.
could I ask for a reminder from Hearings Officer Larson, how much time everyone started off with, and a reminder of how much people have left? That will put things in context for me, I think.
Yes, thank you, Commissioner McGowan. So each party was allotted 6.5 hours, and currently KPK has 1 hour and 33 minutes remaining, and staff has 2 hours and 34 minutes remaining.
Did the additional 15 minutes that we added for the second closing, is that contemplated already in the 6.5 hours?
It is not.
Okay. So I haven't read the motion yet, and I think it's pretty short. Would everyone be comfortable taking 15 minutes to read through this? And I take it we all have access to OnBase, take a look at it, and then we can reconvene after a short break and decide whether or not we want to hear from the parties on it. Commissioner Messner?
Thank you, Mr. Chair. I'm fine with that. Is there any way we could just get this emailed to us?
It's being emailed to you right now.
Okay, that'd be great.
Thanks. Okay. So it's 3:57. Let's come back at 4:12, and we'll go ahead and consider the motion.
Thank you, Mr. Chair. We should be good to go now. We're just transitioning from the break screen back to our normal screen, and we've brought counsel to staff and counsel to KPK into the meeting as well.
Sounds good. Myself and the rest of the commissioners have reviewed this motion. It's pretty short, pretty direct. I'm inclined to give each representing counsel 5 minutes to make their arguments. I can't imagine it'll take that long, but that's what I'm thinking. Do I have any objections from my fellow commissioners? Seeing none, we will get started. We will hear from KPK's counsel first, since they brought the motion.
Thank you, Mr. Chairman. Can you hear me? It's Kirk Mueller.
I can.
I don't know why my video is not coming on, but if it does, fine. And if it doesn't, you know what I look like. Thank you for giving us just a few minutes. The truth is, Your Honor, Mr. Chairman, we discovered as we went through the process during the first 5 NOAVs that our story takes longer to tell, frankly, than staff's does. We have to explain our operations in the field. We have to explain the network of pipelines and flow lines, our process for responding to spills. We had 2 expert witnesses, one of them talking about historic contamination, one talking about ability to pay. It's just not a story that's as readily presentable as the staff's is. And, you know, please note in our motion, we asked both parties be given extra time. Staff does not apparently feel in need of it. But certainly it's our intention that both sides would be equally availed of extra time, and it's fine with us for staff to have that. But for our own purposes, for us to give a reasonable presentation, you know, that's comprehensive enough for you to understand our side of this story, we respectfully request additional time, 1.5 hours. It would bring us to a total of 3 for the 3 remaining NOAVs. And as a practical matter, during the first 5 NOAVs, it took about an hour for us to get our story across.
Thank you, Mr. Mueller. We will hear from Ms. Stafford now.
Thank you, Chair Gonzalez. As KPK represents in their motion, we oppose this request. You know, quite frankly, this was brought to us very early this morning, just before 8:30 to be exact. And we really do not feel that there is any additional time necessary aside from the amount of time that both parties were allotted here. You know, staff opposes this motion because we have tailored our presentation to the allotted 6.5 hours. And, you know, KPK points to the parties' stipulated facts as a reason they require more time here. And, you know, we would think that the facts would streamline both parties' presentations in this matter to focus the commissioners on what's truly at issue in each alleged rule violation. You know, staff reminds commissioners that we have the burden and we have fit our presentations into the time constraints you've provided. And in addition here, I think it might be appropriate if you want to consider this motion for some additional time. You know, we should be given an opportunity to respond in writing here. And I think, you know, ultimately staff does not feel it's necessary to enlarge the time that the parties have been given in this matter. And so that's the reason we oppose here. Thank you.
Thank you, Ms. Stafford. You know, in considering the motion from Respondents Council and just in thinking about all that we've been through today and this past or last week, the importance of having all the information, I think that we are in a best position, at least in my opinion, to have all the information presented to us in a way that we can ask questions, that we can timeline it appropriately, we can cover any gaps in the timeline. I'm inclined to grant the 1.5 hours to both parties. As I've seen it go down for the last week, it takes about a half a day to get an NOAV presented to us. We have 3 days set aside for this hearing. I think that would get us through midday Friday to have all the NOAVs presented and give hopefully a working afternoon this Friday ahead of our deliberations the following Monday. So that's what I'm thinking. I'll leave it if my other commissioners have anything to respond or any opinions on it. Commissioner McGowan.
Thank you, Mr. Chair. So I agree, this is new for all of us. It's new territory. That being said, everyone has started off with the same amount of time and it was agreed to. I'd like to split the baby. I'm wondering if we can make it through this week with the 3 last violations and see how far we get. And then my understanding is then we're taking up the other remaining issues. And maybe we can see if we still need more time after that. I mean, I'm hoping we kind of have a rhythm now that we kind of know with our first 5 what to expect. But maybe not. I'll let other people weigh in.
I appreciate that suggestion. Commissioner Messner?
I appreciate the suggestion, Commissioner McGowan, and I appreciate your thoughts, Chairman Gonzalez. I think the parties knew where the goalposts were at the beginning of this, and I'm not inclined to move the goalposts at this point. I think that does create an unfair advantage to one party over the other, particularly because I do believe that staff's been careful in their utilization of their time, even though they have the burden of proof. And so I'm inclined to dismiss the motion.
Thank you, Commissioner Messner. Commissioner Nanjapa, I saw you had your hand up as well.
Thank you, Mr. Chair. Yeah, no, I think there's some reasonable, considerations here. One question I just had before I weigh in is, are we the amount of time that we have remaining is just simply for the remaining 3 NOAVs? Is that correct? Not for the other matters? Is that correct?
That's correct, as I understand it, and I see Commissioner AAG Davenport giving the thumbs up.
Oh, my apologies. I thought it was for everything.
Okay. I agree completely with Commissioner Messner's comments. On the other hand, I also feel that getting the full scope of information is helpful in making an appropriate decision. So I'm inclined to give an additional total hour to each, so that it would be a total of 7.5 hours for both parties, which would essentially give a little bit less than what KPK is requesting, but would provide a little bit more time, and based on kind of the original allotment of approximately 50 minutes per NOAV, that's what would remain for them, and then in fairness, staff would get additional time as well if they need it.
Thank you, Commissioner Nanjapa, and I appreciate everyone tolerating my chair by committee here. I am going to go ahead and make a ruling on this, and I appreciate all the input. I did the calculations on kind of what the average time frame was for the NOAVs, regardless of party, and I came up with 53.2 minutes, and that would dictate about 2.5 hours, and thought that my initial plan was to limit it to an hour of additional time. So I'm going to go with Commissioner Nanjapa's suggestion. I'm going to give each party an additional hour to present their or add it on to their time frame for the presentation of the remaining 3 NOAVs before us. I see Commissioner Davenport, or AAG Davenport, popped in. What do you have to say?
Mr. Chair, I do believe we need a commission vote on this motion. It's not an evidentiary objection where you would have authority to rule on it yourself.
Thank you. Thank you for keeping my power in check. Commissioner Nanjapa, since this was your idea, would you be willing to encourage or to offer a motion?
Thank you, Mr. Chair. I move that we grant each party an additional hour of time.
Good.
All those in favor?
Aye.
Aye.
Okay. Looks like we have a motion, a vote approved. So we will go ahead and add an extra hour of time to each respective party's total time for the remaining 3 NOAVs.
Thank you, Mr. Chairman.
Mr. Chair.
With the note that just because you have the time doesn't mean you have to use it all.
Absolutely.
Noted.
I'm sorry, Mr. Chair, I've got a request that we confirm the vote for the record. Was that a unanimous approval?
I believe we had 4 ayes.
Okay. Then, unless I'm mistaken, I think the only thing we have left today is a motion to adjourn, and I do want to confirm the start time for Monday's hearing. I think the agenda says 9 o'clock. Is that going to work for commissioners?
Commissioner Messner?
Monday? I thought we had a hearing on Wednesday.
I'm sorry, I must have misspoke. It's this Wednesday, 2 days from now.
Can we keep the 9:30 time that we've been using? I have kids starting school, and I just want to make sure everyone gets to where they need to be in the morning.
I agree with that, Commissioner McGowan. I think 9:30 is an appropriate start time. It's been working well for us so far. So I would ask Hearings Manager Larson to make that amendment to the agenda ahead of Wednesday.
Happy to do so.
what's next, AAG Davenport? Commissioner Messner, you've got your hand up.
Oh, I thought we were ready for motion to adjourn.
I think that's all we have left, Mr. Chair and Commissioner Messner. We just need a motion to adjourn to Wednesday, August 18th at 9:30 a.m.
Commissioner Messner, would you like to make that motion?
I make that motion.
Second,
All those in favor?
Aye.
I'm going to say nay just because I know Commissioner Mezger's trying to get somewhere. I'm kidding. Yay.
All right.
Yes.
Thanks everyone for their participation. Thanks for all the thoughtful engagement. And we will see everyone on Wednesday at 9:30 a.m.